stand here and mention.
My lords, we had filed a review petition against a writ appeal order passed by this honorable court, my lord. The matter was pertaining to pay scales in the HMT company, my lord. My lord, it may be tagged with serial number 54 today, my lord. I appear for respondent, my lord, serial number 54.
54 is will decide today. It will follow the judgment of. You may file review, not difficult.
My lord, short accommodation may be given.
No, it is
I have
covered.
already informed the appellant counsel.
54 is already covered by that judge.
Yes, my lord, but I have produced certain documents, my lord, along with my statement of objections, my lord. And also I may be given opportunity to file the compilation of judgments. Short accommodation may be granted.
We are disposing of that matter today.
My lord, may I?
We will, in any case, we will not be able to take a different view. Whatever document you may file, further documents.
My lord,
For us, it will not be possible unless the
in fact,
review is considered or Supreme Court allows it, or that is a different thing altogether.
the
We are
appellant
bound by
has-
our own judgment.
In fact, the documents what I have produced.
Even then, we will not be able to take the difference.
My lord, may I?
So that will dispose of 54, law 54. You.
I may be given opportunity to argue, my lord.
That you may, then let it be called out. 215, 230.
Please.
All right.
My
Your
lord,
lordship's leave, my lord.
my case be tagged to 54 or?
No,
a
not
date-
to be, it can't be tagged.
A date may be set, my lord.
Date 22nd July.
Oblige, my
Contempt
lord.
matters, my lord, where non-compliance of the order, my lord, we filed a contempt petition, my lord, in February, March, my lord. It has not been put up. Can I request, my lord, to take up those matters?
Yes,
my lord?
madam.
My lord,
Don't break line,
Fine,
yes.
sir.
my lord, writ appeal matter, my lord. The urgency in this matter is, my lord, there is a writ petition that has been filed by the respondent in this appeal, my lord. And it has been directed by the honorable single bench that it may be clubbed with the appeal matter, my lord. Now, his entire service is being in question because of this appeal, my lord. The urgency is that he is.
So it is directed to be tagged with appeal?
The direction by the honorable single bench is that the writ petition that has been filed
Pass
may
it.
be.
Where is that direction? Where is that direction?
My lord, by order dated 27/6 of 2024, my lord. By that order.
You produce the order, then only we'll consider. Yes, Mr.
Pledge, ma'am.
Yes.
Petition number 16, my lord. Similar matter is listed yesterday. That matter is posted on 30th of this month, my lord.
30th.
30th of
30th.
Lord,
number 16.
the 4 matters, my lord, which were filed, my lord, in March, my lord, contempt matter, my lord. That may be taken up any day convenient, my lord, next week or.
It will come. Once you remove the office of objection,
No, office objection is complied, my lord. There are no office objection.
then within
In
work.
2 matters, my lord, there are application, liberty was given to revive the contempt, your lordship. I have filed, my lord.
It will be posted. There is no limit of posting the matters here.
You know,
So any number of matter can be posted once you remove the
no,
office.
there is no office objection, my lord. Therefore, I am moving.
Then it will be posted. Why do you worry?
Filed in March, my lord, that's the, filed in March, my lord. and
Filed in
February-
March.
March, my lord, that's the reason. Otherwise, I would not have.
The matters are not listed.
One
March
is
matter.
filed in 18/3, my lord. One is filed in 21/3,
You people
2020.
mention the matter that filed in March, January, but then we find out that you never remove office of objection. You give the number, which are
Yes,
the numbers?
yes.
You will verify. If you are wrong, then we will not notify you. Because in 2 matters, it turned out to be,
In 2 matters, my lord, revival application has been filed.
You had
In
never
2
removed
matters,
the
fresh
office.
matters, my lord.
you had never removed the office of objection, your colleague.
I have seen, my lord, I have verified. I will, true, my lord, that is there.
My lord, serial number
Like-
13, my lord, 13, my lord.
So get the number.
Yes, sir.
If it is clear, we'll.
Please, my lord.
The serial number 13, my lord.
Oh.
And the advocate is not well, he is suffering by viral fever. Therefore, I am seeking 1 week time, my lord. My lord,
24th July.
my lord, serial number 16, my lord. Serial number 16, signed on 30th of this month.
30th.
My lord, it's a contempt matter, my lord. It was filed early in the 2023, my lord. Notice has been issued, my lord. Since then, the matter has not been heard, my lord. Because of the inaction of respondent authority, the accused, my lord, the illegal construction has been carried out fastly, my lord.
So it is board on today?
Yes, my lord.
Today it is on
It's a memo, my lord, for posting, my lord. Wait may be given, my lord.
list. Wait, list.
My lord, the building is actually, the walls are being damaged, my lord. The complainant's buildings, kindly post it, my lord.
16th.
Much obliged. Yes.
Serial number 40. Serial number 40, I make a request on behalf of respondent number 2 advocate madam. She is not well. Could I request for a 40 madam? Serial number 40.
Which date?
Respondent number 2,
Which date do you?
any day after 2 weeks.
Then
She had
24th
dengue.
July. 24th July.
Please, would like.
My lord, petition has purchased the iron ore during the year 2006, my lord, and has made a certain representation. And has not taken any, no action towards my representation, my lord, and urgency is there.
What is the urgency?
Because, I am the successful bidder, and
Either. Let it go to 15th. 15th.
Lordship, serial number 74. Just now they have given me the compliance affidavit. And I have to look into the compliance because it is a partial compliance. So 2 days time may be given you.
15th.
50.
My lord, serial number 71, my lord. Wherein IA number 2 for the first time, I am for the appellant. Respondent filed an application stating that there is suppression of facts and referring the matter to policeman. So I want to file a detailed objections on that. And grant me 3 weeks time. Because certain certified copies I have to obtain and file it along.
Contempt.
71.
6th August.
17.
the serial number.
Kind permission. 71.
So contempt matters, seal number 1. Mr. Anand Kumar.
I appear for the state.
This is a clear violation of an interim order. My lords had on the last occasion directed the government to
Secure the records, your lordship. Lordship, may kindly, we'll secure the records is there. 2:30, your lordship, may kindly call.
Seal number 2.
lordship order 11/6. The lordship had directed them to report compliance.
Yes. Who
That's your lordship, may kindly take it up tomorrow minutes.
Tomorrow. Tomorrow.
Seal number 3. Ajay Mir.
Appealing for the complainant, my lords. My lords, in the instant matter, the complainant accused were husband and wife. Married on 19/9/2009, my lords. The same came to be dissolved on 6/2/2023. The same may be found at Annexure A, my lords, page number 17. The marriage came to be dissolved through a memorandum of settlement, my lords. The contempt here relates to clause 7, my lords, where both the parties are to facilitate both the documents of the kids regarding Aadhaar card or passport, my lords.
So what is the problem?
My lords, the accused herein has failed to hand over the passports to the complainant on 5/7/2023, my lords.
Fail to?
Hand over the passports, my lords.
Fail to?
Failed to hand over the passports.
Endorse the passport.
Passports, my lords.
Who will endorse the passport?
The accused, my lords, the wife.
Why? Where is the direction?
Clause 7 of the memorandum of settlement states that they'll have to cooperate in issuing all the documents between each of them, my lords. A notice in this effect has been also issued on 23/4/2024, my lords. The same may be found at page number 52.
Which direction is that?
My lords, at page number 19, my lords, clause 7. The petitioners shall cooperate with each other to provide personal identification records, passports, certificates, or any other documents.
Notice returnable on 22nd July.
My lords, notice may be issued, my lords. Notice may be issued.
Please.
Seal number 4,
I appeal for
Natar.
the accused state in this matter.
My lords, complaint is before my lordships seeking for the willful disobedience by Tahsildar.
4,
respondent number
5,
1.
6 notice returnable on 5th August.
Please.
Obliged.
And serial number 5 and 6 are identical similar matters, my lords.
6th now. 6th also same.
Number 7,
Hearing for the complainant, my lords. Issue of transfer, there was a direction issued by coordinated bench to accord me posting within 15 days.
Where is that 15 days?
My lords, it's at page number 32.
15 days is not stated. It is stated.
It is stated, my lords, page number 32, last paragraph, respondent number 1 state shall take decision within a period of 15 days from the date of receipt of copy of this order.
Page.
32, my lords, page number 32.
Yes.
The last paragraph, after accordingly writ petition is disposed of.
Notice returnable on.
May I request for a shorter date, my lords, because no posting since 10th of April, my lords, 3 months without posting,
Order is 18th of July.
18th of July. I'm grateful.
seal number 8,
Lord, the
Provide
operative
general
portion of
duty.
the order is, my lord, running page number 24. This honorable court directed, my lord, to the authority respondent, that is accused number 1, to reconnect, my lord, within 7 days, the drainage to the canteen.
Notice.
Lord, my humble submission, my lord, from March, my lord, there is no connection. After the order also, my lord, he is not ready to give the connection.
19th July.
Emergent notice, my lord,
19th July.
please, obliged.
PL matters. Seal number 9, Mr. Vasantappa.
Present petitioner in this case. For the direction issued by the tender notification issued by the government, my lord, the respondent BBMP has constructed the retaining wall at ward number 52, the residents of the petitioner area, my lord. And they have constructed the retaining wall to the stormwater drainage, my lord. They have completed either side of the drainage, my lord. At page number 70, may kindly be looked into, my lord, which is the annexure E. They have left out a gap measuring 40 feet, my lord. Because of this, my lord, the entire water come into the area and flooded, merged with the bad smelled water, my lord. And in the last year, my lord, page number is 63, may kindly be looked into, my lord.
What is the issue?
My lord. Issue, my lord, they have not completed the stormwater drainage retaining wall, my lord. Either side of they have completed the retaining wall at the 10th cross dead end, my lord.
Which page?
In page, my lord, page number 70. 70.
What is 45?
My lord, this side, my lord, they have constructed the entire area, my lord, with the height of 15 feet. But in the dead end of the 10th cross, my lord, they have left out only, they have constructed only 3 feet of retaining wall. And they have planned to construct a culvert.
My lord, I take notice for respondent number 1. Notice will have to go to the BBMP, my lord, because they are the ones who are constructing this wall.
If he is right, then there is little urgency in it. Because both rainwaters
Yeah, my lord, the photographs
flood-
reflect that, my lord. Page
flooded
1.
inside the societies. Yes. It comes in the society,
Please,
residential area.
my lord.
The water comes into the residential area.
Please, my lord. Photos, my lord, the compound wall, my lord, entire compound wall is merged. That is nearly 6 feet water is there.
You give copy to the council appearing for BBMC.
Yes.
Please,
2:30,
please.
ask him to be here, whosoever appears. Only one council appears or panel is there?
My lord, the panel, my lord. And they go by, my lord, the ward wise.
Who is your friend you give copy to? Amongst the panel, whosoever is your friend,
Panel.
close friend, all are your friend, but then 2:30.
Number 10, so A Nagarajappa. I appear for this.
My lord, the allegation, my lord, in the writ petition that in an agricultural lands, an activity of, my lord, a commercial activity including the unauthorized construction, establishment of the liquor shops were the complaint. Page 108, my lord, the learned
Establishment of what?
liquor shops.
Liquor shop.
Liquor shop. Page 108, my lord, the learned single judge, you file a public interest litigation. It is because of this, my lord, we have come before this court. But page 54 is the report as on today, based on not only my complaint, there are others. There is a report of investigation team. There are more than 9,976 cases which are now pending. They will have to be proceeded with a logical handminutes. Page 54 is the investigation report. The relevant portion, blood, is at page 57. It is found that 1,007 property registered issued so and so. Out of 949 files were physical files submitted in a team by the office staff category Revenue Branch Kolar Municipal Corporation. As for the reference, Kolar City issued a show cause notice. Now this has to reach the logical end. Without a conversion, they can't use the agriculture lands into a commercial activity. This is a report dated 15/11/2023, submitted by the Deputy Commissioner to the Directorate of Municipal Administration. The local body has to carry out the investigation.
Heard learned advocate Mr. So and so for the petition. Petitioner who is engaged in the business of manufacturing bricks and earning livelihood therefrom, claiming to be a public spirited person, has filed the present public interest petition to espouse a cause and to raise a grievance inter alia that there has been a mushroom growth of unauthorized construction of buildings and formation of sites and allotment of such sites by the revenue authorities. It is the case that not which is done without having due regard to the provisions of different laws different laws, LAWs. The second limb of the paragraph. It is stated by the petitioner that he came across several loopholes in the functioning of the revenue department. And the agricultural lands are allowed by the department to, not to, for the purpose of building houses. It was submitted that especially in Kolar and around the Kolar district, the lands are utilized for non-agricultural purpose without conversion. Paragraph. The second limb of the grievance appears to be permission granted at several sites by the revenue authorities for opening of liquor shops, which, according to the petitioner, is done under the garb of CL-7 license with boarding and lodging, which are innumerable, which are also lodging, the instances of all instances thereof also are innumerable. With such paragraph, basic premise of action, the grievance, the petitioner has prayed as under. Then page 20 of the direct bracket was directing the respondent authorities. It is also stated by the petitioner, making part of the prayer, that with regard to the grievance as aforesaid, representation dated 4/3/24 is made to the Secretary of the, Department of Revenue. And similar representation is also given to the Deputy Commissioner of Revenue, Kolar. However, no action are taken. The basic grievance of the petitioner is that the pockets of agricultural lands are permitted to be utilized for commercial and other non-agricultural purpose. It is also the grievance that on certain sites, are permitted for utilizing them to run the liquor business, which again is not in accordance with the provisions of law. Paragraph. The allegations made in the petition, true, are serious enough. However, they are too vague to be countenanced by the court by entertaining public interest petition. Full stop. It is noticed that the petitioner has made representation to the competent authorities. Also, the petitioner is permitted to pursue the representation. And if any specific instances are noticed by the petitioner may point out to the competent authority about the use of the agricultural land in violation of law. Full stop. If such representation is made by the petitioner, the competent authority of the respondent shall consider the same by applying the provisions of law under the different texts as may be applicable and take necessary measures if required. With the aforesaid observations and without expressing any opinion on the merits of the subject matter, the petition is disposed of.
Page 93 and 90, representation is already.
Number 11, Mr. Shivraj Naradi.
Lords, I appear for the petitioners in this matter. Yes, Annexure A, my lords, at page 32. Yes. Passed by the second respondent, my lords, demanding to pay the environment compensation, my lords. You are there?
Yes, Your Lordship.
Yes.
I take notice for the board, Your Lordship.
You have noticed, you not. You won't notice.
Uh,
Notice returnable. Or-
There are connected matters on the same point, Your Lordship.
This is that environment company.
Environment.
Environment.
Please,
No, Your Lordship, there have been reviews which have been
So
filed.
the group is kept when
Uh,
possible.
please, my lords.
Will issue notice returnable.
My lords.
Final order, that is the issue.
Your Lordship, they have an alternative remedy.
Alternative remedy.
Yes, there,
For-
there have been, judgments have been passed by this Honorable High Court and review petitions have been filed. All the review petitions along with different writ petitions have been connected together on the same point of law to be decided.
I myself is appearing, my lords, in those review petition, my lords. What has been challenged is that, my lords, these.
No, other petitions are kept when.
Well, that's, I was given to understand by the council is that it's coming up on 4th.
Fourth.
Yes,
My lords, dates
because
were
well, it's
given.
that bench, that it should be in constituted bench with Justice Krishna Dikshit. It can't be the same bench.
My lords,
Take your
20
time. Let
Sir.
your colleague argue, yes. Yes, when it is coming.
On the 4th, Your Lordship.
Fourth we'll keep on for.
Please, my lords,
Simply.
along with the review petition.
You won't notice returnable.
My lords,
For
meanwhile, let them
learned
not
advocate
precipitate,
miss.
my lords. There are interim orders.
Accept notice. You are
A.
accepting notice?
A. Mahesh Chaudhary, Your Lordship.
Mahesh Chaudhary accept the notice for this one policy.
My lords, if I may request, they're all small micro enterprises, my lords. There should not be precipitating stay, because in other connected matters, there is a stay.
We don't think they are precipitating.
My lords, there are stay orders in
They are
connected.
cooperating in hearing. About you, we
My
don't.
lords, there are connected matters, my lords, there is a stay, my lords. What happens? The
If only
officials will come, they get, these are all very small enterprises.
Connected matter, there is a stay.
They are
And they will connect you to your matter. also.
very much. Stay may kindly be.
It will connect to your matter. Stay in the connected matter will connect in your matter.
I mean, on 4th, the review petition and writ petitions
If
are
in
coming.
one matter there is a stay, then it will apply to all. That is what we're trying to point out. No need to pass fresh order. They will not violate in cases other.
They have been undertaking also before your lordships that they will not precipitate. If they say.
We don't think they are the councils, at least councils are not that unreasonable. About the client, we don't. So no need to pass any order. Fourth, we'll consider.
Much.
If any difficulty, then you can mention on. fourth.
Please.
This is seal number 12, Ravindra Gajanand Kulle.
Yes.
Is my lords. It's identical matter, my lords, on other day. the matter of- Same,
Which
but
is kept
I'm,
pending. We'll then decide the matter fast. So that matter. That 8-day extension. What
there
is
are
the-
totally 4 matters filed on the same day. So they are coming on split days, my lords. And things are getting improved. I will be placing only 3 points, my lords. Very brief submission I will make, my lords.
This will keep on, today is what?
It is, all the connected matters are posted on 11th.
15. This may come on 15.
No, all the connected posted on 11th.
11, then 11.
So, but I may kindly be permitted to highlight only 3 points about Rule 8A2, Rule 8A4, and Rule 8A8, my lords. Very short submissions, because other day in my absence, my lords.
We made the councils to re-argue the matter. Your colleague was there.
Yes, my son, my lords, he has presented to the best of his abilities, but
So what do you want to submit now?
I will say that rule 8A2 may kindly be seen, just opening words, my lords. 8A, sub rule 2.
8A2.
Yes, my lords. The opening words itself say that all the quarrying leases or licenses. There is nothing as reclassified minor mineral or any such things. It is
In
all.
your case, it is not granted.
Beg your pardon?
In your case, it is not granted.
Yes, I was granted earlier to 12/8/2016, my lord. That's what is the requirement of law.
Granted but lapse because of non-renewal.
That rule is that 8(4) is omitted, deleted with retrospective effect from 12/8/2016.
You want us to construe the section in unreasonable way.
No, my lords, I will be submitting only in accordance with law, in the sense, sub-rule 4, which makes filing of the renewal applications 90 days earlier to the expiry of the lease deed in terms of erstwhile rule 21(2), which was deleted effective from 12/8/2016, that itself has been omitted. It is nowhere in the statute books. That has been brought into effect from 17/3/2023 with retrospective effect from 12/8/2016, my lords, as if it is not there. This has been misunderstood or I think not properly placed before my lords. Because the requirement of filing a revision petition and the requirement of filing the application 90 days earlier to the expiry of the quarry lease itself is omitted effective from 12/8/2016. If it is not there as on the date of 12/8/2016, how can that be brought in here, my lords? That this goes against the total amendment carried out effective from 17/3/23, my lords.
Mr. Mahendra, you just interpreted subsection 8 last time.
That also I will clarify, my lord.
You give the notes.
Yes.
How they are not three different categories. You give your notes.
Yes, I.
But my only submission.
Within 2 days.
Yes.
My only submission for rule 8 is that is read from any angle, it is applicable only to reclassified minor
That
mineral.
we are examining. But Mr. Mahendra has different argument last time.
That argument is unfounded according to law. Because non-obstante clause, 1 point, number 2, stated therein, not herein. Therein means, my lords, from.
You also give your synopsis before we decide. This will kept in 11. Because we are in process of deciding one of the first must matter in first point of time, reserved. So then everything will follow.
Please, my lord. But these things only.
You want to give synopsis or?
Yes, I will be giving, my lords.
By within 2-3 days?
Within 2-3 days or by latest by Friday, I will be able to submit to the court, my lords.
Very well.
Please, my lords.
One submission.
Yes.
This 8A8 came into force from 12/8/2016.
Yes.
This entire amendment, sea change amendment brought into Karnataka minor mineral concession rules in order with the view to introduce auction regime. That was introduced in the Parent Act from 12/1/2015. There was a major amendment carried out to the Parent Act, MMDR Act from 2015. May I draw your lordship's kind attention to Section 8A9. A similar provision is there in the Parent Act. That is applicable to the. Please.
8A9.
Not in that, in the Parent Act, MMDR Act.
Parent Act.
These are all the rules framed under MMDR Act. This, for the first time, Lord, in the year 2015, even in the Major Act, this concept of deemed extension was introduced. Renewal of leases.
Which is that 8B? Which provision?
8B is different, 8A8.
8A.
8A8.
8A,
Here it is 8A9 in the Parent Act.
8 and 9. Yes, the provisions of this section.
The provisions of this section, notwithstanding anything contained therein, shall not apply to a mining lease granted before the date of commencement of Mines and Minerals Development and Regulation Amendment Act 2015, the 10 of 2015, for which renewal has been rejected or which has been determined or lapsed.
So the perimeter language
Yes,
indicates the intention of the legislature,
intentions,
both uniformly to be considered.
uniformly, because it can't be contrary to the Parent Act itself.
I'm very sorry to say that, my lords. Section 14 of 14 of the MMDR Act may be seen. Section 18 is excluded in respect of minor minerals. Section 14, I may kindly be permitted to be
Of this act.
MMDR Act, main MMDR, Mines and Minerals
Yes,
Regulation Act.
we have,
Section 14
section 14.
reads, Section 5 to 13, not to apply to minor minerals, is the heading.
I do admit it will not apply.
If it is
I am just bringing to the notice of the Honorable Court the intention of the legislature as to why this particular section has been introduced for the first time in the year 2015, and correspondence rules have been
In
framed
16. In 16.
in 16.
But my submission would be, this is the reason why 102 mining matters were taken to Honorable Supreme Court, and it is still pending. And the observation is that it is blissful ignorance of mining laws.
We'll consider. This will go to 11.
The thing is, when this is not applicable to minor minerals, where is the question of referring to Rule 8A, my lords?
Understood.
Please, my lords.
So this may be given.
Uh, 13 urgent, number 14. Mati B. Vidulata.
May I add one word, my lords, with the leave of the court? There is no corrigendum issued for major minerals. Only in respect of minor minerals, so it is not there. Only 31 minor major minerals have been reclassified as minor minerals. That's all. So there is nothing to say that that is brought in under MM's rules.
We'll
my lord.
consider.
Sorry, my lords, for interpreting.
14, my lords, this is a request, my lords, that is made to the respondent. The petitioner wanted to dig a well, my lords, in her agricultural land. 6 months was given, my lords, by the authority. Permission was given to dig the well in 2022, my lord. She could not complete it within the 6-month period of 6 months
Right.
due to bad weather.
May-
That's
may-
why she's requesting for
We'll
extension of
consider the
time.
representation within 4 weeks.
Uh,
Representation
Positively, my lord.
in accordance with law. And next year,
My
ref
lords,
will
what happens is, Rule 3A
Want-
says it is only for
Want
6 months.
extension of working permission.
Just to dig a well, my lords. If it is a rocky area, I have to take permission. I have to pay royalty to transport those minerals also. Kindly see Rule 3A, my lords.
Initially, it has been granted for a period of 6 months.
Yes, my lords, I'm
As
not,
per-
why they will reject is why I'm bringing it to your lordship's notice. 3A, my lords. The following activities are exempted from obtaining quarrying license or a lease or license and from the provisions of so and so. Digging of well for irrigation or drinking water or rainwater harvesting. My lords, they have granted me permission, but kindly see, my lords, the first proviso. Provided that in case of clause A, B, C above, prior working permission in writing shall be obtained from the jurisdictional deputy director or senior geologist before commencement of extraction, and that the removal of minor mineral shall be done within a period of 12 months
from the date of grant of permission. Now this 12 months has lapsed. So if they take it by the face of it, my lords, they will not be able to grant me extension. I have made a request, my
You're
lords.
given six,
I have, 12 months has been
6 months or 12 months?
12 months. It's over.
In total 12?
Yes, my lord.
6 plus 6?
Yes, 2022 itself, it was granted, my lords.
So 6 months extension?
We are asking for 6 months extension.
No. Earlier you were given 6 months, then you sought extension.
No, my lords, only once. They have not given me extension.
So then what is paragraph 6?
Yes, my lords.
So the permission letter dated 10/3/22, fourth respondent given 6 months.
6 months. After that, no extension has been granted. We are asking for 6 months.
Further
But
six-
now, from the date of the working permission, 12 months has lapsed.
So you are saying 12 months?
My lords, here it says 12 months from the date of grant of working permission.
Which provision?
The same proviso, my lords.
Lie.
Same proviso. The same proviso. The senior geologist, before commencement of extraction and the removal of the minor mineral shall be done within a period of 12 months from the date of grant of permission by the
So
jurisdiction.
maximum 12 is permission.
12 months. So we are saying 6 more months if they grant us, we will complete it. That's all, my lords. We are not asking for anything more. 2022, the weather was really bad, my lords, so we could not complete it.
I think they are justified. At least doesn't appear to be any.
Nothing else, my lords.
Nothing else.
If it is for a well, more than 6 months is not required. If they go deep into the well,
I have.
then it might require years together. That is the,
What?
in the guise of digging the well,
Let the photographs be perused, my lords. We have not extracted or.
let the competent authority consider, will consider and pass a.
We'll say that the ground appears to be justified.
Yes.
In that light. That is how we'll couch the language.
If there is a factually, if
Not say positively,
Please,
in accordance with law.
in
But
accordance.
we'll say since the ground appears to be justified, we will consider it.
yes, please. Yes,
We'll pass the.
that would be a positive.
That will not be positive.
It will not.
That would be positive for me, my lords.
There you go.
Great.
We'll
my
say
lords.
ground appears to be justified, ground pleaded and the circumstances narrated appears to be justified, therefore you consider in accordance.
Please,
We'll
Obliged.
pass the order, yes.
Great.
Oh.
So within how much time?
4 weeks.
4 weeks. Very.
Obliged.
Yes, what is it?
For 15.
Approach the state down to file revision. Under 53(2),
Which?
I may permit it to file revision. There's an alternate remedy, your lordships.
Last. Disposed of. What? So what do you want? Withdrawing?
Withdrawing to file a revision.
Learned
before
advocate.
the Revisional authority.
What is your good name?
My name is Kusmar Prasad.
So and so, 6 for the petitioner upon instructions, 6 permission to withdraw the present petition in order to stating further that the petitioner will opt to file.
I filed a memo, your lordships, as per the memo.
File the what?
I filed memo seeking withdrawal to approach the state government, your lordships.
To approach
Revision
the
available
state
under
government
Rule 53(3).
by filing revision application. Full
Yes,
stop.
your lordships.
Learned advocate has filed, not learned advocate for the petitioner files memo dated 2/7/24 in this regard, which reads as under, quote the memo. In view of the above, permission is granted to withdraw the petition with liberty reserved as above. However, without expressing any opinion on merits of the case of the petition.
Much obliged, your lordships.
Petition is disposed of accordingly. Thank you.
16 urgent, writ appeal matter, still number 17.
My lords, I appear for the appellants in this matter. My lords, this matter is relating, my lords, to revision of pension, my lords. My lords, what has happened is, my lords, KPCL, my lords, has for, my lords, time followed the state government orders. My lords, on 3/5/2012, the state government, my lords, passes a notification, my lords, revising the pension. And it creates 2 categories of retired employees, my lords. Employees who retired prior to 1st April 2012 and employees who retired after 1st April 2012, my lords. My lords, KPCL, my lords, now, my lords, with reference to the government notification, my lords, passes its own memo in November 2012, my lords, and creates 3 classifications. My lords, with respect to employees who retired prior to 1/4/2012, KPCL, my lords, creates 2 classifications, my lords, with respect to employees who first retired before 1/1/2012, 1/1/2011, then employees who retire between 1st January 2011 to 31/3/2012, and employees who retire, my lords, post 1st April 2012. My lords, the learned single judge, my lords, in
May I make one submission? I'm sorry to interrupt, my lords. I'm appearing for response number 3 to 9, who are the writ petition of the learned single judge, my lords. I've entered appearance. I've not yet been served with the papers. The learned counsel for the appeal may be directed to serve the papers on me, after which, my lords, the honorable committee director.
my lords, notice was not ordered. My lords,
Notice
which
was
is
not
why
ordered, my lord. There's no
I've
urgency.
served a
Just
copy
why-
on the state government.
He's appearing.
Please, my lords, I'll serve copies, my lords. I have no difficulty. I'll serve copies, my lords.
I'm grateful.
My lords, if I just may make one submission. My lord, the learned single judge, my lords.
You are for KPC.
Please, my lords. The learned single judge quashes the memo because, my lords, he says that KPCL is required to follow the state government orders. My lords, my submission is, my lord, that the state government order is followed. My lords, if page number 98 may be looked at.
You copy, then we'll come.
Please,
I'm
my lords,
grateful.
I'll do that.
8th of July.
Please, my lords.
8.
Please,
Please,
my lords. Oblige.
Please.
Grateful, my lords.
I'm obliged.
Number 18. I appeal for the appellant so far. Lords. For the appellant. The appellant is formerly Vijaya Bank, which is now Bank of Baroda, my lords. The respondent was selected for a post of a probationary post of middle management grade scale 2. He entered a service agreement with the bank, undertaking to serve the bank for 3 years, my lords. Within 6 months' time, he submitted a resignation letter to say that he has been selected for appointment in SAIL, that is Steel Authority of India Limited. And he agreed to pay the bond amount of 3 lakhs because his service with the bank was less than 3 years. Subsequently, he raised a claim to say, please refund my bond, because there is a guideline from the Department of Public Enterprise to say that in case there are shift in employment in public enterprises, the bond need not be served and it can get transferred to the new employer. The case of the bank is that the bank is under the Ministry of Finance and not under the Department of Public Enterprise. And the learned single judge's judgment, relying upon the DPE guidelines, is what I am aggrieved by and before this honorable court. There is a delay of 200 and odd days, my lord. And he was selected for a fairly senior post, my lords, an officer cadre as a chartered accountant to do the internal audit of the bank. And knowing fully well what the terms and conditions of contract are, he chose to breach, and then he agreed to fulfill those terms. At a later stage, he makes this claim. And the payment is also made to the company, to the bank.
Page 30, clause B will apply of your policy, that circular guideline.
Yes, my lord, that
Guidelines.
the guidelines at page 127.
Which clause will apply? B?
My lord?
Which clause will apply of guidelines?
No, my case is that these guidelines don't apply to me because they are only to.
According to
the learned judge. Please,
your
my lords.
bank, your bank.
I'm the bank.
So it is B which is applied, page 30. Go to
Page-
page 30.
This is, yes, my lord, this is contained in the circular of
No,
the
no.
EPE.
It appears that the learned single judge has said that this guideline will apply,
Yes, my lords.
which is against you.
Yes, my lords.
So which is that clause which is applied by learned?
My lords, kindly see page 127, my lords. My lord,
127.
127 is the guideline itself.
Yes.
Clause number 2, my lords, the last clause, last provision on page 127. All administrative ministries, departments are requested to kindly issue an essay. This is what the learned single judge relies upon to say it ought to be applicable.
Which part?
My lords?
Which part of this circular is applied?
The whole part, B, my lord.
That is what we are saying. Page 30 is quoted.
Yes.
In the order.
All these, there are 3 provisions, my lords, in that circular. All of them are series of guidelines as to how these bond issues may be applied. And
How this will not apply to you?
my lords, if my lords may see, I am a bank under the Banking Transfers Act, and I am within the administrative control of the
You are
Department of
not
Finance.
central government enterprise.
My lords, I will
Is
not
that-
be, I will not be under the administrative control of the Department of Public Enterprise, my lords.
Or learned advocate, Mr. So and so, notice returnable on.
There is a delay, my lords, if I am seeking condonation of.
Delay is there.
Delay is there.
Only
See,
notice.
Please, my lords, because there is an order directing me to pay that money within 3 months, my lords may kindly consider. Because this will have a C effect.
How much? Your own title says you are under Government of India enterprise.
No, I'm a Government of India undertaking, no doubt, my lords, but I am under the administrative control of the Ministry of Finance and the Finance Ministry and the Economic Affairs Ministry. But the Department of Public Enterprise is under a different ministry and different department, my lord. And in fact, the bank we have been informed that this circular has not been circulated through our department to any of the banks.
It might be a micro classification. This may not be permitted. Once you are under the
What is the-
umbrella of the government of
May I make one more submission, please, my lords?
What is the delay?
My lords?
Delay is
Delay is on account of delay with it,
the extent of.
224 days, my lords.
So on 15th, notice is on 15th, or notice is on 18th.
Please, my lords may consider.
Delay, there is no
Delay.
question.
Please, I am grateful.
We'll consider the demerits
And
after delay.
2 more submissions for my lordship kind consideration is that the rules and applicable for a bank for taking in selection and the rules of transfer are completely different from the Department of Public Enterprise, my lords. That is a stand that I have taken in the reply also. And also this is a claim under a contract, my lords. A writ petition in my humble submission may not have been maintainable at all, as this is a civil dispute. Grateful. 19. Returnable.
18th.
My lords, if another day, a day later, my lords, on 18th, I have some personal inconvenience.
19th?
19th. I'm grateful.
Mr. Number 19,
Lord, I
Bill by
appear for
government.
the appellant. My Lord, the respondents 1 to 15 were
Number 19, Bill by government.
My Lord, I appear for the appellants. My Lord, the respondents 1 to 15, my Lord, they were appointed as a group C employees, my Lord, in the respondent number 16 institute, my Lord, against a sanctioned post, my Lord, in the year 2006. My Lord, the government decides to absorb them as a
One-time measure.
one-time measure, my Lord, and thereafter, my Lord, within a span of 3 months, decides to withdraw that order, my Lord, wherein because of financial stringency,
How can you do that?
my Lord,
Having once done it.
my Lord, I'll convince my Lord, let the notice go, my Lord, and then I leave it to my Lord after my Lord, I'm relying on certain decisions. My Lord may consider those decisions and then may pass any order, my Lord.
So you are withdrawing the status of regularization, indirectly, or directly rather, after granting it.
Yes.
So whatever may the ground, you can't do that.
My Lord, I'll convince my Lord, notice may be issued. I'll rely on certain decisions, then I leave it to my Lord.
Notice returnable on 23rd July.
Right.
Bill number 20,
Plus 20 for the appellant, my lords.
Manish Kumar.
Appellant, lords, the acquisition, please, my lords, is of the year 2006. The challenge is late, please, my lords, in the year 2022. My respectful submissions are, the challenge, my lords, was of
2006 and challenge in 22,
22,
15 years.
15 years. Based on earlier, my lords, judgment, please, my lords, the learned senior judge would come to the rescue of the petitioner saying, please,
So
my
that
lords,
is our judgment.
award does not pass. Lords, in my case, lords, what transpires is, there was a Lokaayukta inquiry which was pending, please, lords, files were taken away by the Lokaayukta. After we receive back the files, lords, from the Lokaayukta, we proceed to pass the award. My respectful submissions are, lords, the layout is formed, industrial layout is formed. Allotments are also made, please, lords. After 16 years, my lords, they have come up before the court, please, my lords, and the acquisition insofar as the petitioners, my lords, stood quashed.
So what learned single judge done?
Lords, the learned single judge relies only upon, please, my lords, the earlier instances. Lords, what transpires here is, my lords, had come up in the first instance, my lords, before this honorable court. There was a remand, please, my lords, to file a review. I filed a review, please, my lords. In the review, please, my lords, again, it was dismissed. Lords, page number 44, please, my lords, at paragraph 9 onwards, my lords, is the finding rendered
And
by
you are,
lords.
how you are agreed?
Lord, this is the acquisition notification, acquisition is completed. Lords, the allotments are also made, layout is found, allotment is also made. After 16 long years,
Petitions are dismissed.
the learned single judge dismisses it, my lords. Or the learned single judge allows it and dismisses, sets a quashes, my lords, the notification.
Where is that order? Letter?
Lords, page number 44 onwards, my lords. Order of the learned single, in the review, please, my lords.
Now, what is this, then page 23?
23, please, my lords.
Say that judgment.
My lords, this, my lords, an earlier order. Earlier order, we had come up before this honorable court. This honorable court, please, my lords, remanded the matter and directed me to go file a review. First instance, my lords, at the stage of notice itself, my lords, the acquisition notification stood quashed. We had approached, please, my lords, and we filed an intra-court appeal. It was remanded, my lords, to file a review. I had filed a review. In the review, I will again, please, my lords, the learned judge has been pleased to set aside the quash the notification. Over which, my lords, this is the second round, please, my lords, of appeal.
Hard learned advocate Mr. So-and-so for the appellant. Having considered the submissions and further gone through the impugned judgment in order of law and a single judge, the appeal requires final hearing. Appeal is accordingly, appeal is admitted. Full stop. The acquisition was finalized in the year 2006. After issuing the necessary notifications in law, the same came to be challenged in the year 2015.
22, my lords, the challenge was
22. Full stop. The delay itself makes out a prima facie case for grant of interim leave. By way of interim leave, it is directed that the parties shall maintain status quo with regard to the subject matter land.
So there is,
667 days.
the
Delay is there.
delay is, my lords, only on this reason. I had come up.
Then we will not be able to grant any stay. That is all. Notice returnable on. Serve them. 18th of July.
My lord, I take notice for respondent number 1.
Sir, there you bring.
My lords, my respectful submission is earlier instance, my lords, same notification has been quashed, please, my lords, before this honorable court. That, my lords, had been escalated to the apex court also.
Regard to lapsing of this scheme.
It is
But
lapsing.
my submissions, my lords, are what is the law.
Ground of non-taking of possession.
But in this specific case, my lord, the file was with the Lokayukta.
We'll consider. In any case, there is no question of granting stay. Notice returnable.
My lord, I take notice for respondent number 1.
But 21,
Reply.
K.P. Krishna.
21, I represent the appellant counsel. An essential condition.
Respondent. What is the writ appeal is filed, my lords, by intervening applicant before the learned single judge, which application was rejected. After the orders of the learned single judge, there are certain subsequent events, my lords, which I want to place on record, which will have a bearing on the consideration of this matter. Lords, may I have this matter, my lords, on Monday or Friday or on Monday, my lords, I'll place those materials.
What is the matter?
That is an essential condition of a tender, but which was essential for the entire tender, has been dispensed with by the order of the learned single
But
judge.
you are.
I am the L2 bidder, second lowest bidder.
You are respondent, one of the respondent or not?
My pleading application has been rejected by the learned single
Pleading,
judge.
yeah.
Yes, has been. I filed an appeal to prosecute the appeal. Lords, the essential condition is at 11.1, page number 67, if lordships are.
We'll grant time, Mister. Let us, not that we will not grant. But let us prima facie understand what is going on.
Lordships.
11.1.
11.1, page number 67.
Yes.
If my lords are to see 11.2.
Yes.
This lot is a contract for supply of sandalwood oil. The documentary evidence.
Oil.
Sandalwood oil.
Sandalwood.
This is for sandalwood oil. The documentary evidence of the tenderer's qualification to perform the contract, if its tender is accepted, shall establish to the petitioner's satisfaction that this is the clause, that in the case of a tenderer offering to supply goods under the contract, which the tenderer did not manufacture or otherwise produce, the tenderer should have authorization as per authorization in section 13 by the goods manufacturer or producer to supply the goods in India. This is the Lord's form which is required Lords to be submitted. May I request now Lordships to kindly see the form at page 102.
So you are unsuccessful bidder. He is successful.
His technical bid came to be accepted. Thereafter, my lords, they asked him to produce this certificate, which is an essential condition. But he produced a certificate not of the manufacturer, but of the supplier. Therefore, my lord, tender was cancelled. Tender was cancelled, a fresh bid was called. Learned single judge holds that you accept whatever the certificate which has been given and go ahead and award the contract to him. Kindly see page 107. In fact, it's 102. There is a fixed format given, which more prescribes the manufacturer's guarantee to be given to the tendering authority as to the place of manufacture. Lordships will kindly see V dash, who are established reputable manufacturer of dash, having our factory. They have to specify the factory. Now, what he produces is at page 121. He produces the certificate of a supplier at page 121. But may I request Lordships to kindly see page 122. Typed copy.
So this condition means that the tenderer can buy and then supply.
This condition means, Lord, that he has to produce, he has to have an assured.
If he is not a manufacturer.
He is not a manufacturer.
Product, then he has to produce
A certificate from the manufacturer.
So he can buy from the manufacturer and supply.
True, very true. For that purpose.
Not buy from the supplier and.
Not necessarily from the supplier. It has to be manufactured. And the manufacturer is your content. That's all. That is the content. Manufacturer has to guarantee. That knowledge has been sought to be dispensed.
Lords, now, the learned single judge only directed that the tender should be taken to a logical conclusion. After the learned single judge's order, the tender is already awarded. Lords, the nature of contention.
Awarded to you.
Yes, awarded to me. Now the nature of contentions rise as to whether I'm eligible, ineligible will be disputed questions of fact over which, Lords, again, I'll have to place my, but section 16 of the KTTP Act says, Lords, a person who's participated in the tender process is entitled to challenge the awarding of the contract in my favor under section 16 of the KTTP Act. So now that the direction is given only to take the tender to a logical conclusion.
But there is no scope now left. The learned single
But
judge
it's not direct, Lords, that the appeal should be considered
the
without
learned
being prejudiced with any of the observations.
The learned single judge holds dispensation of that condition, award the contract to him. That is the effect of the order.
That's
But
not
unless
the-
this order of the learned single judge is set aside, the question of Lord's I going before any other authority does not arise. But what my learned friend says is I should file an appeal of awarding the contract to him.
Yes.
But on the face of the findings recorded by the single judge,
So there's
there will be no
findings
scope for
recorded.
an appeal at all.
I'm for the respondent number
Appeal.
one. Please, ma'am.
Appeal.
Appeal. It's an appeal, my lords. If, lords, what the learned single judge says is that since I was L1, subsequently L2 gives a complaint. On the basis of a complaint given by L2, you cannot say that the certificates which has already passed the muster of the evaluation should again be revisited. So therefore, learned single judge says that the tender should be taken to a logical conclusion.
The learned
Now,
sing-
having taken
the
the
learned
tender-
single judge quashes the decision to reject his application and go for a retender. Learned single judge quashes that. But if the order of the learned single judge is restored back, Lord, the fresh tender will have to be called. The question of I going to file an appeal, Lords, in the face of finding of the learned single judge does not arise.
Because there are factual
Lords have
assertions
to see
made
the
for
order
the
of
first
the
time.
learned friend should not interrupt when I'm making submission. But if he wants to make a submission, Lord, kindly see Lord, at page 42.
No, order of learned single judge,
At page, operative portion is at page 42.
page 40.
On submission, my lord, I'm for respondent number one, my lord.
Order,
Please work on.
writ petition is allowed. Order dated 7/3/2024 passed by the first respondent stands quashed. That is the order passed by the tendering authority, rejecting his document for bid and going for retender. And then what learned single judge directs respondent company to direct it to take the tender notified on 14/10/2023 to its logical conclusion. In other words, meaning award the contract to him. There is nothing else remains.
Lordships may have this matter next week, so I'll place all the materials to show because there are factual assertions made for the first time in the writ appeal.
But this.
For supply of.
Lord, this is a tender for supply of
Supply
standard
of oil. But
Lords,
now.
I'm a supplier. I'm a supplier from the.
Is to be relegated to appeal, then everything will be over.
Lords,
Not only that, in the face
I-
of learned single judge order, question of why filing an appeal does not arise. Appellate authority is bound by the order of the learned single judge.
No issue.
Question, yes.
Lords, I will definitely,
Please.
Lordships may have this matter on Tuesday or Wednesday, my lords.
Whenever.
Till
I'm a
then,
supplier since 5 years.
I have requested,
The
but till
sixth
then,
year.
let them not, my lords, take any action.
This is
which
only
would-
loud
already taken.
participation. We are not concluding anything.
But second, the first respondent company is before your lords. Let them not,
Now-
my lord, go ahead and award the purchase order.
Issued on 18/6/2024, my lord.
You are for?
I'm for respondent number 1, my lord.
Who is it?
Please, my lord.
Who is?
KSDL, my lord.
That is what is the role?
This is, my lord, soaps and, but there is a government of India, Karnataka company known as Karnataka Soaps and Detergents Limited. It is, my lord's, very world famous, it manufactures this Mysore sandal soap.
What is
And-
the role of? the
But
clerk?
they are the tendering authority. They are the tendering authority.
Tendering authority.
Yes,
The tendering authority, my lords.
at page 319, my lord, the
Lords,
technical
I-
committee sits down and says that it is
Even,
not
even
eligible.
the present appellant has already been blacklisted. Lords, those materials, I'll place it on record. It
Let him
is for
show.
supply of the standard.
Let him
oil.
show that I am blacklisted.
Yes, I will place all the materials before the court. They are already blacklisted. Yes, so therefore, my lords, I'll place it. Yes, the appellant is blacklisted.
Blacklist.
Yes,
Let my lordships may record that statement,
Yes,
that I am
lords.
blacklisted as on today.
Yes,
Then I will be in a position to, let him not make allegations of
I
admissions
stand on
without
instructions
any
to say,
foundation
stand
or
on
basis.
instructions to say that the appellant company is blacklisted.
You show that he is blacklisted
Lordships.
for the purpose of this tender also.
Yes, not for this tender, my lord.
No, he has not
Pertaining
been
to the other tenders where he has participated, there he has been blacklisted
No,
pertaining to certain tenders.
You have to show that blacklisting is in operation when this tender was.
Totally incorrect statement is being made.
Yes,
I have
my
appeared
lords.
for these matters earlier.
When do you want? It is 10/6. 8th, 9th.
8th or 9th, any date, my lords. 8th also, my lords.
I have no difficulty with
Lordships.
9. But till then, my lord, let them not take any action.
There
which
is
would
no
ren-
further
which would
action to be
render my
taken.
appeal.
I'm
No, no.
already, lords,
No,
it's
my
a
learned,
supply.
I would tell, let them not render my appeal infructuous. All that I am saying
Will
is
it
that,
be rendered infructuous? How will it
but
be
let them
rendered
not take
infructuous if we don't
precipitative, any
understand,
action,
lords?
Lord, which would
They are
result.
supplying the oil from the past 5 years.
No, as on today,
Tender
my lord,
is
the
given.
order has been issued, work order has been issued, they say, my lord, now. Let them not precipitate the matter till, my lord's lordships hears the matter on 9.
Lords, your lordships is accommodating till 8th, my
Don't
lords.
change equities till 8th.
Yes, lordships may say.
We will not claim any equities till 8th, my lords.
Eight,
Lordships.
That's a fair
Please.
rule of the game.
Lordships.
Yes.
Grateful, my lord.
8th we are keeping.
Please, please.
Number 22, to Lokesh KV.
For the appellant in this case, my lords. The petitioner is a cooperative bank, my lords. The respondent
which cannot be appreciated at all. It emanates from the tenor and terms of the aforesaid pleadings taken as a whole that the intention of the party is unfair and deceitful. It is only repetition and relitigation for no legal purpose for prolonging the proceedings only at the cost of this tribunal, which is purely an abuse of process of the tribunal. The applicant cannot collaterally attack the proceedings initiated by the defendant, invoking the provisions under the act by filing numerous petitions for amendment of the pleadings. If it wants time to settle the matter, the remedy lies elsewhere. The tribunal has taken a careful and serious look on the matter as a vexatious litigation absorbs its precious time and valuable time. Filing of the subsequent IS seeking the same amendment is clear abuse of process of the tribunal and cannot be encouraged at all. The Honorable Supreme Court in so and so.
What about other two applications?
Milords,
What about other two applications? There are three applications.
all three applications, Milords. 3 amendment applications were filed. What happens in
All are amendment applications.
all are amendment applications? This was absolutely considered. In fact, Milords, I am placed before this court, more recent Supreme Court judgment.
For
Two cases similar on this case.
Why not? Why Supreme Court judgment in such simple?
Because similarly, Honorable High Court of Telangana had quashed the order of Honorable DRT in the essay in appeal, which was quashed by Supreme Court. So
No,
they should avail alternative remedy, Milords, because for availing alternative remedy, they should deposit 50%.
No judgment is needed, if you are right. Heard, learned, advocate, Mr. Sir.
Obliged.
Notice for final disposal. Returnable on. In the page 46 was in the first round or second?
Milords?
Page 46 was the first round of litigation.
Yes, first round of litigation.
Then we are dealing with the second stage of the litigation.
This has to be challenged by way of appeal before DRT under section 18.
Notice returnable. 18th.
I may pray for interims because DRT may.
Thing will happen for 15
The DRT, there's a direction for disposal of this matter within 30 days, Milords. Lordship may kindly see the single bench order. He has directed the DRT to dispose within 30 days. There's a time limit fixed to the DRT. Within 5/8, the order should be. Amendment application was considered and rejected. Has allowed the amendment application and has remanded by, what's I am on mental immunity, Milords. The appeal remedy is available and for under section 17. Section. Milords, he should have considered alternative remedy should have been, and it was considered, Milords. In the order, it's very much clear. No. Lords, the amendment application was rejected by the DRT and what? Let's see, there's no order of rejection. the Honorable DRT has said it is considered. It is not that it is rejected. My lords, the amendment application filed by him was considered by DRT. That's what my case is. Was considered. The single judge should have sent them to DRT.
That the other party has the opportunity of being heard in respect of amendment application. Nothing wrong in it. Sorry. There is nothing wrong in it. Yes, next.
Lord, it's an appeal against an interim order. 23 and 24 are connected. My lamentation appears in 24.
I will pay in 24.
It was earlier heard? No.
No, my lord. First time it is coming up. My lord, the issue is like this, my lord. There are two appellants before your lordships. They were respondents 3 and 4.
Lordship, may I make one mention, minutes? Appeal for a central government. Learned ASG has been briefed in the matter. Could it be taken in the afternoon session? He has got some personal inconvenience to be here today.
Take up, but
This is.
As a prelude, let us understand. Will not be final.
That's
what is it?
Yeah, my lord, matter is like this. There's a TV channel called Power TV that is owned by the second appellant. The learned single judge, my lord, has taken note of certain documents which are not part of the record.
Owned by second appellant.
Yes, the owner of the channel is the second appellant. There is a service providing agreement between second appellant and the first appellant. That is documented. There's an agreement and there is a sharing of facilities and other things. The main case, my lord, is this writ petitioner, my lord, who is respondent 2 in this appeal, who is respondent number 2, my lord. He is a police officer. Some news items were published against him. So there is an ongoing, long-standing battle between the two. He's given complaints to every conceivable authority under the Act, filed number of cases, got interim orders. Number of things have happened. He now, my lord, moves the central government to say you cancel this license and stop this channel which is being run by the first appellant, he says. Actually, the first appellant is not the company which is running the channel. The owner of the channel is the second appellant. All licenses are in its name. The prayer in the writ petition was for a direction to the government to consider his complaint.
Whose complaint?
Complaint filed by the writ petitioner. Writ petitioner submitted a complaint, my lord, to the government to say there is some violation that these people have indulged in. So please take action. That was his complaint. And his case is that they didn't consider it. He files a writ petition. The prayer, my lord, in the writ petition at page 59.
Subsequent developments.
One nimsha, sir. I will place all subsequent developments.
We'll end once the prayer is read.
Yeah.
No further. Yes.
Page 59, my lord.
He has been
In
running
the
a
prayer
channel
in the writ
without a
petition.
license.
Issue a writ of mandamus directing respondent number 1 to consider the complaint dated 4/3/24 filed by the petitioner, consequently take action by stopping respondent 2 TV channel from telecasting, broadcasting news. Then interim prayer, please to direct respondent 1 to shut down and close respondent 2.
This complaint was against TV channel.
Yes, against the TV channel, against my clients.
So what this petitioner,
The petitioner says that this channel.
What interest petitioner was grinding for this prayer?
He has been running a channel without a license.
Is that the channel should be closed.
What was the interest of the petitioner in making such a prayer?
No interest. He has nothing to do. Means he is, my lord, a police officer. He has no interest so far as this company is concerned. His case is that this company.
But what is the ultimate controversy now?
Controversy, my lord, he raises is that we are operating a channel without license. That is his case. So you shut it down. So he gives complaint to government.
What is the order of learned single judge?
Learned single judge, my lord, passes an order stopping the telecast, directing that there shall be no telecast, channel shall shut down.
Till such time you obtain a license.
That is not the case made out at all. That's not his prayer. And my lord, what happens?
The presence of the central government is necessary for this reason. I'm not having any quarrel with Manan. Central government says before the learned single judge, this controversy does not survive because there is no license granted to him and license has not been renewed.
That's not correct, my lord.
Yes, yes.
I'll place, my lord, material to show that I am legally entitled to run this channel. I have all permissions.
Will consider 2/3.
Please. My lord, there's one permission I need, my lord. What happened? One show cause notice was placed before the court. It was not told to us. Learned judge refers to that and extracts from it and makes it a part of the order. That is not part of the record at all. So I filed an application, my lord. If your lordship permits, my lord, I'll file it in the registry and it may be brought up, my lord. I have it ready, my lord. I'm filing the show cause notice which they submitted before the court without making a part of the writ petition. And that is the basis for the order. Permit me to file that and my reply to that.
No,
I've
that was
served
placed
copy
by
of
the
that.
central government, not by the petitioners.
Since how long you are running the channel?
2011.
2011.
Without license?
No.
No, my
For
lord.
10 years.
I have a license. No, my
For
lord. I
10
have a
years it
license.
was there.
My lord. No, my lord. It's not correct. I have a license. I have obtained all the permissions and I am entitled to run, my lord. That's what I'll show.
Will
My
consider.
lord, very interesting, my lord. Union of India, council stands up and says something. Petitioner council stands up and files some document. And based on that, my lord, an order is made.
Will consider.
Not even the prayer in the petition.
And 20.
Consideration of complaints in contempt matter, seal number 25. Iglina TN.
Well, order under contempt, my lord, page number 9.
20.
A direction was issued, my lord, to consider the request within 8 weeks. My lord, matter pertains to settlement of retiral benefits, including pension. They are retired in the year 2020. Till now, my lord, they have filed, my lord, they have filed, my lord, a affidavit on 30/3/2024, stating that, my lord, they are complied with the order. But the affidavit dated 30/3/2024 may be seen at page number 66, my lord. But it's an internal correspondence between the government and the university. 66, my lord.
Your veterinary university.
Like university requirement. They have admitted, my lord, they have no problem with that. But the government is, my lord, issued a letter to the registrar. It's internal correspondence. Now saying that it's a complaint. Not, no order is passed. Yes, my lord, since 4 years, my lord, we are not paid any pension benefits. They have to settle it, my lord. Under the old scheme, that's our contention.
Why don't you pass an order on the basis of this?
They have passed it.
Already.
They have admitted that, my lord.
Told us that it's not possible. They're
The
not
u-
entitled to the OPS. They're entitled
The
to
university letter is page number 7, my lord.
This internal correspondence is addressed to you at some point?
No, my lord. That is addressed to the, this is between, one university has admitted page number 7, my lord. In the same affidavit, my lord, compilation, page number 9. The university at page number 10, my lord, last paragraph. They have no issues with that.
I am directed to inform that there is no provision to apply the old defined pension scheme to the.
That they are saying, my lord, but that's not the correct position.
The state to register.
Yes, my lord.
Somebody must communicate to you.
No, my lord, that very position taken with the government is not correct.
But now by virtue of the production in the affidavit reply, it amounts to.
My lord, may I request your lordship, page number 9, my lord, 10, in the very same affidavit.
Now you are aware about this. It is disclosed in the affidavit.
No, my lord, kindly look at page number 10, my lord, for a minute, ma. Page number 10. The university being the appointing authority, page number 10, my lord, last paragraph.
What page number? 10.
10 in the last paragraph, further. The said regular daily wages employees are
Number
working.
10 of what?
Affidavit, very same, my lord, affidavit.
Yes.
My lord, further, last paragraph.
Yes.
Further, the said regular daily wage employees are working since 1784 and due to administrative disruption to the said regular procedure, despite order was passed on 1478, the daily wage employees are eligible for earlier pension. They are admitting, my lord, the government.
Why don't you issue formal order? Formal communication addressed to him.
Please, your lordship may kindly appreciate, we are an.
Your
autonomous
university?
institution. Yes,
Huh.
we have addressed this letter to the government.
Right.
Government has refused, they said no, they have been regularized in 2008. The by that time, the
Madam,
new pension scheme has come into force. And we issued an endorsement to that effect. Challenge that endorsement.
Where is that?
That is there in my counter.
Then it is an end of the matter.
My lord, they are not given any endorsement to us, my lord. That is
Page 60.
Endorsement, your lordship may kindly say pay.
R2 in the affidavit, they filed, my lord, page number 17.
16/8/2023.
69.
Your lordship, the
27/3/24.
16/8/2023 is
Page?
my endorsement.
Page.
Page 17, please,
70.
of my counter.
There's a counter.
Counter filed by me
My lord,
on 21/11/2023.
Nice. Seventeen, actually. Page 17.
my lord,
It refers to the internal correspondence.
Your lordship.
This is
my lord,
reference.
yes, kindly look at, my lord, page number 22 in that very same, this one.
This is with reference to those internal correspondence only.
Yes.
You are
Internal
communicating.
correspondence, my lord, what they, may I request lordship, what they are saying, they have forwarded to the government, that's all. Internal correspondence later. Kindly look at, my lord, the page number 22, my lord. 22, the very same, this one, my lord. 22, my lord, last paragraph. All these aspects are examined in the meeting of
That
one
is on merits, Mr.
Lord, of their, the very same of the last, that endorsement, very endorsement.
Which endorse?
That page number 17 endorsement, my lord,
Yes.
they have produced. My lord, I may permit to read page number 22.
Yes, page 22. Yes.
Yes, ma'am. Last paragraph. All the aforesaid aspects are examined on 1/8 meeting of management of Board University has instructed take approval of the finance department to provide pension and gratuity to be given to government daily wage employees. As per the said resolution, the letter has been written as per reference it in order to issue approval to the finance department. This is, they are saying that, my lord, they have followed to the government. Thereafter, the government issued a communication. My lord, there is no formal order. They are saying that, my lord, they have decided to forward it to the government approval regarding the settlement of pension. My lord, this was dated, my lord, 16/8/2023. And my lord, the government communication, my lord, 19/12/2023, subsequently communication of the government.
Where is that internal?
Please, my lord.
Where is that internal correspondence?
That is, my lord, page number 66 in the affidavit filed with the government.
Page
number 66 in the affidavit filed by the government.
Kindly take page 69. The government has issued an endorsement pursuant to that dated 27/3/2024.
Page.
The learned prince will be saying
Page.
R10.
He is saying that there is no formal order.
There is no formal order, my lord.
Your lordship may kindly take page 69. The government has issued.
The 27th, will be there.
29 Kannadama, it is there. 27, that is what I was pointing out. 27/3/24.
Yes, sir.
This is some kind of
But they're saying that, my lord, we have to submit certain accounts for some new pension scheme.
Yes.
In fact,
Our learned advocate, Mr. So-and-so, so-and-so, for the contempt petitioner, from learned advocate Miss Vishali Hegde for respondent.
For respondent number. Two.
Two to
Two, your lord.
And learned additional government advocate, Mr. Jafar Shah for
A1.
respondent, one state. and
Yes.
its authorities. The jurisdiction of this court under the Contempt of Courts Act 1971 was invoked in respect of the following directions issued by learned single judge in his order dated 28 March 2023. In page 12, paragraph 3, without expressing an opinion in merits. The representations which are required to be considered the representative petitioner required to be considered were about payment of pension and other statutory retirement benefits to the petitioner in terms of order dated 1/7/17 of the university. Paragraph. In response to the notice, respondent university as well as the state government have filed their respective compliance affidavits. Respondent 2 university passed endorsement come order dated 16/8/23. In which it is entirely stated that the communication is addressed for the purpose of the approval of the finance department for all pension, for applying all to decide as to all pension or new pension scheme would apply to the daily wage workers regularized after 1/4/2006. Full stop. Also filed the compliance affidavit by the state government stating inter alia, pointing out inter alia that the university was already intimated where is that 69?
Page 69.
Page 16. 61. By already intimated by communication dated 19/12/23 that the petitioners are not entitled to be regularized
Old pension.
and the is mandatory for all persons who got appointed within the state government on 1/4/26 to apply for partial benefit of pension scheme. And that there was no provision to apply for all defined pension scheme to the petitioners. Both the aforesaid orders, both the aforesaid communications figures on the record of the proceedings along with the, filed along with the, annexed along with the respective affidavits. It transpires therefore that after the university passed endorsement dated 13/8/23, the issue of entitlement of old benefit for the petitioner employees was examined by the state government. Full stop. Consequently, communication dated 19/12/23 aforementioned was addressed to the registrar of the university, conveying that the petitioners are not entitled to be given the benefit of the old pension scheme, and they have to apply it for the new scheme having been in employment on or after 1/4/2006. Full stop. An argument sought to be raised by learned advocate to the petitioner that correspondence that communication dated 19/12/23 is only an internal correspondence and does not amount to any decision on part of the government. Full stop. The said communication dated 19/12/23 reflects a decision-making process. Full stop. Learned advocate for the petitioner is not right when he submits that there is no decision. Inasmuch as endorsement dated 27/3/24 figures on the record along with the affidavit of the state government in which it is provided that the petitioners are not entitled to the benefit of the old pension scheme. In that view, the representations are duly decided and the necessary endorsements are passed. Nothing survives in the contempt proceedings, as the order could not be said to have remained uncomplied with, as the directions could not have been said to have been remained uncomplied with. It is our clarified that if the petitioner is not satisfied with the decision, it is open for the petitioner to challenge the same in accordance with law in independent proceedings on merit. In respect to which this court does not express any opinion. The contempt proceeding is accordingly disposed of.
Yes, number 26, Srinivas V.
Honorable Court had directed the complainant to publish certain documents.
Today we have morning we have furnished, my lord, because they asked for certain documents.
Parties have exchanged the documents in process, which shows that the respondent is in compliance of, in the process of complying with the directions put up on 22nd July. By that time, you complete whatever process.
This number 27, to PA Kulkarni.
I beg to appear for complainants in both the cases, my lords.
Yes. What is it about?
My lords, what has happened here is they were all working as a part-time lecturers in the government junior college. And
Lords, we have filed a compliance affidavit. It is similar to the serial number 23, my lords, old pension scheme and the new pension scheme. We have considered and issued an endorsement, my lords, which is at page 7 of the count.
5/5/23.
Please.
Annexary
5/5/2023.
5/5/20.
Please.
So nothing survives, Mr. Counsel.
may I submit, my lords?
Yes.
May I submit, my lords?
Yes.
My lords, that the endorsement is issued by the director PU board. He is not the competent authority to decide about our claim.
That is a very good ground to challenge it. But
No, my lords, the direction issued by this honorable court is competent authority should decide.
it may be a ground to challenge the order or endorsement, but not contempt will not survive.
My submission is state government has to issue the order.
In view of the in view of this court, endorsement of order dated 5/5/23, produced at annex three into page 47 along with the compliance affidavit. It is correct, 5/5.
Please, five.
Compliance affidavit by the state government marks the purging of complaint, purging of contempt, as the direction was only to set the representation and pass appropriate order, pass the necessary orders, full stop. What is sought to be submitted by learned counsel for the petitioner that the authority who has passed the endorsement is not competent over it. This could not be ground to be urged in contempt proceedings, full stop. If the petitioner is inclined to challenge the endorsement on the said ground, it is open for him. However, this court does not express any opinion on the merits of such recourse, as well as the merits of subject matter contention. In any case, the contempt petition does not survive and it is disposed of accordingly.
It's a similar.
Endorsement dated which? Don't say yes, whatever we say, because we say like anything. We are wild in saying. Which is the endorsement, 1/3 or 5/5?
That's 5/5/2023, and this is 1/3/24. In this matter, it is 1/3/2024.
Second 1/3. Second matter is 1/3.
1/3/2024.
Second no, orders identical, except 5/5, it is 1/3. Thank you.
That's, like, all the contentions may be kept open, my lords.
Yes.
That may be part of the order.
Number 28. So Vijay Kumar SC.
Bring for compliance.
Yes.
This is a compliance
What
affidavit
is it?
was filed on the 29th of this. Yeah. There is no contempt in this matter itself, your lordship. The direction is not against any authority, only say not interference.
In this case, there is a, not to interfere with the possession of the land in question. I sought for protection from the police. In spite of that, the respondent accused has issued an endorsement stating that there is a road in the land in question. For that, I have filed the contempt.
That he has to approach the proper forum and say that he has to
Well,
challenge that order.
he has relied upon a sketch prepared by the authorities, but the sketch does not mention the existing of road.
What you are saying, yes, please repeat.
Please.
So the direction is not to interfere with the possession of your possession.
Please.
Yes, sir.
So that they have interfered.
Well, the accused is mentioning that there is a road existing in our land itself.
That cannot be sought in the contempt
That
petition.
is my contention. She is relying on the sketch prepared by the authorities, but that sketch will not show any existing of road. Page number 19, your lordship.
The directions, your lordships. The learned single judge himself has said there's a disputed question of fact. He has to approach the proper forum.
To the contempt.
Maybe, your lordship, she is relying upon
For
the,
attracting the jurisdiction under the contempt court, there must be a positive direction which you can enforce. Which is that direction in this?
your lordship, not to, there is a clear direction. I will read that impugned order.
Read it.
However, the learned counsel for appearing for the petitioners argued in para 7, your lordship. Order of the learned single judge, page number 14. However, the learned counsel appearing for the petitioner argued that the petitioners are in possession of the land in question and the respondent authority directed not to interfere with the land in question. If such being the case, unless the land has been acquired in a manner known to law, the respondent authority shall not interfere with the possession of the petitioners. In this background, I made a representation to give a police protection. The accused written a letter to the police authorities that there is a road on the basis of the sketch prepared by the authorities. That sketch that does not disclose the existing of the road. It is at page number 19, Your Lordship.
What is the contempt?
She is saying that there is a road existing in our land, that thereby they are provoking the people to interfere with our possession.
We do not know. Road is never coming in picture in this order.
That's why she accused is mentioning that there is an existing of road.
We do not know.
She is mentioning, Your Lordship, in Annexure E, Your Lordship, page number 22.
In an attempt to establish this case, that the contempt of court is committed, from a learned advocate for the petitioner draws attention of the court to the following directions of the learned single judge in order dated 2nd November 23, by submitting that the contempt is committed, by submitting that submitting that they are breached, then court paragraph 7, full stop. He further submits that the authorities are now stating that there is a road passing through the field of the petitioner, and therefore in such way they are interfering with the possession of the petitioner, committing breach of the directions, full stop. The reading of the observations and directions in paragraph 7, it does not contain any positive direction which could be subject matter of contempt jurisdiction. As far as the aspect of road, etc. is concerned, it is in the realm of disputed questions of fact, and the factual aspects which are not otherwise subject matter of the main proceedings could not be gone into in the contempt petition. Also, if the petitioner has any grievance about the conduct of any of the respondents and in his perception.
And you should kindly see, after this letter, the accused have issued another letter withdrawing this and permitting they give the police protection to the complainants.
Conduct of the respondents in law, it is open for the petitioner to institute independent proceedings in that regard, in respect of which this court, however, does not express any opinion on the merits. This contempt petition is disposed of as not entertainable. Yes, next.
Number 29. Mr. A. Murali.
For the petition, complainant.
My lord, I am for the accused 7 to 14, Your Lordship. My lord, the allegation is, my lord, I violated the orders. I disobeyed the orders by putting up additional construction. Your Lordship, I have filed my counter affidavit saying that I did not do any kind of a constructions, my lord.
Pardon?
I filed the counters, my lord, that I have not done any additional constructions.
My lord.
The
on the
allegation is that I disobeyed the order, my lord, which I have not done.
My lord, I've shown photographs. Even on the last date, Your Honor, your lordships were made a note of it. My lords, if comparisons are made,
A hearing date, my lord, was fixed on.
my lords, if comparison is made between photographs which are produced in page number 214 to 216 with photographs in page number 230 to 234. It clearly establishes that they were carried out.
What is page 152?
My lord, this is which was produced in the civil court, my lord. This was in September.
We are giving you the argument. We are not understand.
No, my lords, this is a part of the writ petition record.
That
So-
also we know.
Yes. My lords, page number 214 is
152.
My lord, those are the photographs of my earlier.
Time of filing of writ petition.
no. This is a-
Much before they filed, my lord, they went to the civil court also, saying that their rights of privacy has
The
been.
construction has progressed like anything.
My lord, the construction has been progressed not after the orders, my lord.
How do we know that?
No, after the orders.
No, after the orders, my lord, I gave an undertaking and I have filed the affidavit, counter affidavit also to that.
My lord's page number 214.
These
was at the time of
photographs are of
filing of
old
writ
dates, my
petition.
lord.
Page number 214 onwards are photographs when at the time of filing of writ petition, 214 to 216.
Only those photographs, my lord. One photo is not the same, the other one, my lord. All are different photos and there cannot
My
be any
lord's
comparison on that. And whatever they are submitting, it's not correct, my lord.
My lord's comparison
Your
has
lordship,
to be made.
Your lordship, the allegation is that, my lord, I had committed deviations. My lord, that deviation, the very order itself, my lord.
So these photographs, then there is no much progress.
My lord's 2000.
You are of the under impression that page 152 is the original photograph.
No, my lords. My lords, last date also 214 to 216.
Then you might have weak case. Page 214 and
Yes.
page 230 and 31 doesn't have any much difference.
My lords, I would like to draw your attention to for comparison between in page number 216 and 233. If we can see that they've completed this on the front side of it, this is in a span of 1 month from the date of order and from the date of upload, 233 and 216.
Now this is the page 214 is the status obtained when this provisional order was passed.
No. This was when writ petition was filed, my lord. Writ petition was filed.
No. This is Bengaluru, Brihad Bengaluru Mahanagarpalika passed provisional order.
My lord, provisional order was passed in September itself, my lord.
Instructed to demolish all portions
No,
constructed.
those, my lord, none of that was in my knowledge, my lord.
My lord, they didn't
Orders
accept
that
notice.
has happened. For my lord, that there is a violation. They have conducted inspection is what they claim. And thereafter there is an order passed. None of that was in my notice, my lord, because my lord, as per the act, all that they do is they will come and paste on the wall.
For July affidavit is not one second. Counter affidavit is there, but 24 July. It is not there.
Lordship, I filed it, last week I had given my office copy.
Dekho, 24 July. Yes, it is there. We are sorry. Okay. There is nothing.
My lords, they willfully disobeyed this. In 1 month's time from the date of order and upload, they've carried out 233
They're
page.
inclined to accept the affidavit in view of the fact that the photographs show that there is a gap of only 30 to 40 days within which he could have worked. And there also he has not carried out any much work. Thereafter, he is maintaining status quo. Sorry, dismissed. We find that we'll accept the affidavit and we'll say there is nothing, no contempt is come. So 29. Yes, yes, next.
Number 30.
Not, I appear for the last hearing. Lordship heard the matter for some time, and at that stage, there was a proposal from him to file an affidavit and indemnify. Now he has filed an affidavit. We state the facts. Now, the petitioner,
Lord, I filed this affidavit on 29/6.
This is that matter.
That is where the interest portion, my
Interest
lord, was
portion.
required to be paid by. And the state government, my lord, directed, my lord, for release of the payment in my name.
What is the now?
My lord, kindly have a look at page 59.
It is boiling down to what you're
I
filing.
think that this will
You're
resolve.
filing affidavit.
No, they have filed.
I was directed to
Oh.
file an
My lord,
affidavit.
that-
I have filed the affidavit that in the event of any cross claim as against the state government, my lord, I will take care of it. Please come to page 2 of my affidavit.
Your lordship was pleased to direct on last occasion to the petitioner, the company, to file an affidavit to that effect. If the amount is released to Satya Prakash, they have no claim over.
I have filed.
There
an
was a
affidavit to that
specific
effect.
direction to the company.
No, my lord, it was not for the company. I have specifically sold because the company will not.
We'll recollect the controversy, then take up
Please.
on day after tomorrow. Or 9th, whichever.
9.
My lord, I think, my lord, 1 second will resolve.
Ninth, my
this
lord,
dispute.
will be out.
My lord, kindly have a look at page 59. 2 minutes I'll take, my lord, so that the dispute will be resolved. Kindly have a look at the letter issued by the company. Page 59. Yes. First, that is 27261. In my writ petition.
So far as
Business petition.
company's writ petition is concerned, before my lord proceeding with the hearing of the, whether the a writ petition
259.
seeking review of the earlier order is maintainable, my lord, is required to be decided.
I think, my lord, this will resolve. Kindly have a look at page
locus as
59.
of now. The direction given, my lord, I have filed the affidavit.
Once again.
Company is out of the question. Okay, that's all right.
This is the same thing that we have filed now.
Correct.
That's all.
Lord, I am not claiming interest. My lord, kindly have a look at page 59, my petition. Lord, I will clarify that.
You are the,
I am the company, my lord.
so you are this Praveen Kumar.
Chitrakut Steel.
Chitra.
My lord, kindly have a look at my letter in my writ petition, page 59.
You are one second. So petition is, the appeal is by whom? Petition is by whom?
By me, 27/2/61.
Petition is by Praveen Kumar, is the petition.
No, that petition is, my lord, I'm appearing for Praveen.
So we are taking a which petition?
My lord, 27261/2019, that is by the company.
So where you are the petitioner?
Yes, my lord.
You are the unsuccessful bidder,
My lord, I am the successful bidder.
unsuccessful. Unsuccessful.
Yes, my lord, yes.
So you have got the
Refund,
refund.
refund.
Interest you have not got.
Interest, my lord, what I did, my lord, I authorized the third respondent to collect it.
Kindly, interest you have not.
I didn't get.
Now, you are seeking interest.
My lord, exactly, it is not the case. That is the reason I said, my lord, 2 minutes, your lordship may grant me.
No, we will not give you 2 minutes unless you answer our query. Are you seeking interest? Are you seeking interest?
I am seeking review of the earlier order and payment of interest to me.
We want to be clear on.
Yes, my lord, I am seeking interest.
You are seeking interest.
Yes.
Now, you are financed by this Praveen Kumar. Who appears for Praveen Kumar?
He appeared for Praveen Kumar, madam.
So you are seeking interest.
I have invested.
You are interested in getting interest.
Out of interest, investment amount, what I given to fourth response.
So you want that part.
Yes, madam.
And who is this TG Satya Prakash?
I appear for TG.
What is your role?
My lord, my role is, I'm the investor.
financed him
My lord,
by taking finance from Praveen Kumar.
I also invested, Ravi, between me and my lord Praveen Kumar, we have compromised.
Now in this petition, what is the controversy?
In this petition, the controversy is only this, that the principal amount was released, my lord, I took that principal amount, there is no dispute about that. Thereafter, interest was to be paid. My lord, I filed a writ petition, the state government agreed to, my lord, to pay interest. And my lord, the state government passed an order directing release of interest, my lord, in my favor. And thereafter, my lord, they did not, my lord, pay the interest. Therefore, a contempt came to be filed. In the contempt, there is a direction for the state government to deposit the amount before your lordships, and that amount is in deposit. Subsequent to that, the company, my lord, now has filed another writ petition, my lord, seeking review of the order passed in first writ petition. So far as Praveen Kumar is concerned, he filed a writ petition. They are also investors and they have interest, my lord, in the amount deposited. So far as that aspect is concerned, there is a compromise between me and Mr. Praveen Kumar, and that has been settled. Now, my lord, the company is also stating that interest amount, whatever it is, can be released in my favor as per the authorization letter given to me. In the meantime, my lord, that is what if I understand correctly, the company was trying to draw your lordship's attention to page 59 of the writ petition. Their writ petition 27261. That authorization letter, which starts, my lord, from page 58, my learned friend appears to be referring to the last paragraph. In the meanwhile, take note that we are not liable for any interest, damages, LD or any charges in this regard. I say I have given an undertaking that if there is any, my lord, claim, my lord, in relation to the interest amount that I am receiving, I, my lord, indemnify the state government as well as the company. That is my affidavit. This affidavit, your lordship directed me to file. And accordingly, I filed this affidavit.
Today interest is paid to you.
Where interest is paid to me?
Lying with you.
It's not lying with me, it is lying with your lordship's as per the direction. It is in deposit.
It will go to you.
It should come to me.
Naturally.
That is the end of it.
That is what I.
Now, we have filed a review petition.
So you are not interested.
No, madam, I will take it from the fourth respondent. I will collect from fourth respondent.
We have filed a compromise petition, we are not.
So that part is over.
That part is over.
Now you are not interested.
My lord, now in view of this undertaking, the company's apprehension is
Taken care of.
That is what I wanted to submit that. Because this is the apprehension they have expressed in page 59. They are not claiming the amount, but they say there is an interstate dispute.
No, may I make a submission? we have filed a review petition because subsequently the Chitrakuta, the company has withdrawn the authorization given to Satya Prakash.
It is not the case. We will make a
No,
statement.
that
to
is
effect.
exactly for the reason, Lord. On the last occasion, your lordship was pleased to direct the company to file an affidavit affirming that they have no objection to release the interest amount in favor of Satya.
Authorization is withdrawn by whom?
Withdrawn by the company.
But this
That
is
was given to, your lordship may kindly peruse. the,
authorization to receive interest.
this,
Act as
act as the representative of the company. Your lordship may kindly peruse page number 19, annexure B, please.
that part has to be taken care of. So what do you say about that? Authorization, you are withdrawing the withdrawal?
My lord, in the letter, what they have expressed is, my lord, without any doubt and ensure that we do not face any claim from other parties again. This was, at that time, my lord, there was dispute between these two. That is why we have written a letter to the government, because Satya Prakash saying that the earlier letter will not be acted upon because you have disputed the claims. Now that he is indemnifying this, my lord, if it is company's money, yes, I can say that it should come to me. But at that time, there was a dispute. That is why I said let it come to the company, we will distribute. Now among themselves, they have settled and GO is passed, paying in favor of Satya Prakash.
Petition is separate petition.
Yeah, I have separate petition.
If he withdraws the petition, then?
Not done. We have filed review petition.
No, if he withdraws the petition,
Please.
thereby giving up all everything, every prayer, then your review petition will have no efficacy.
Correct.
No, Mla. No, we are seeking review of the earlier order. The second writ petition seeking interest is filed by Satya Prakash in his individual interest. It is not on behalf of the company. Earlier order was, in the earlier order, in the first initial order, Satya Prakash was representing Chitrakuta, the company. That is produced as annexure B. Your lordship may kindly peruse. In that petition, he was representing the company. There was an order to release the amount in favor of the company. Without noticing that, Lord, in the second petition, the Satya Prakash has filed a petition on his individual capacity, seeking release of interest in his favor. That was not maintainable. Without noticing that, we have agreed to pay the interest to Satya Prakash. That is why we have filed a review petition to review the order in view of the development that now the Chitrakoot has withdrawn the authorization given to Satya Prakash.
So now he is giving up his claim.
He is giving up his claim.
Let him file an affidavit to that effect. That is what we are in.
Then we will make him to withdraw the petition.
Withdraw the petition.
But I'll.
At the same time, he had written a letter to the government not to release.
We'll record a statement. Your whole basis of your review and grievance will go.
Please, all that we are in, we have to pay interest, we have deposited
What is the amount of interest involved?
3 crores.
3 crore 4 lakh.
We have to make sure that.
We will do one thing.
Please.
We'll keep this matter on 8th.
Please.
9th, my lord.
9th. We'll draft an order and we show to all of you.
Obliged.
So that no
My
technical.
lord,
defect
highly
will-
obliged, my lord. Obliged.
You also see on all other.
All other grievances
Not
are,
that
my lord,
we are
settled under this
interested
order.
in, Lord.
My lord, there should not be any further complication
right.
by virtue
So
of.
There
this.
shall not be any
All our-
claim by the company if you.
I had given an undertaking, company is making a statement, state government has already deposited the amount. They are not going, my lord, stating that they are not liable to pay interest. They say that they are liable to pay interest. They cannot take advantage of the internal, some misunderstanding between company and this thing. That's all the issue.
The only thing to be sorted out is between you and the company.
Yes.
Otherwise, things are clear.
Right, that's it. My lord. They cannot, my lord.
My lord, he is undertaking even against the government, claim against the government.
Send over to you on 9th, the draft order. You see and.
Okay.
then we'll-
Yes, obliged.
Obliged.
For 9th, मुझे दे.
Question number 31.
Obliged.
Maitri.
Respondent was in 31.1. Look, this is on.
Pray for time, my lord. I appear for petitioner in this case, my lord. My lord, the objection copies have been served last night, my lord. I need to see.
My lords, we have filed a detailed compliance to the rejoinder filed by the respondents. The copies are sent to.
We have received them.
Yes, yes. If they can look into it and tell us what extra has to be done, we can.
My lord, in 31.1, we had filed objections. 31.1, my lords, we were in fact, we are a organization working against manual scavenging and we were impleaded as R7. And I had filed detailed objections, my lords, for their compliance report. Thereafter, the government yesterday served us their response to our objections. And my lord, we have reviewed it. May I make some submissions? So we have received the government's counter. And there is still non-compliance which we would like to talk about.
That can be placed, my lords. We will get it complied if there's anything from our end. Most of it we have complied, whatever was submitted.
Very obvious from there. Can I just take 2 minutes, my lord? I'll point out, then I leave it for my lord.
So they have not complied with what?
No, my lord. In fact, there are.
What is not complied with?
My lord, there are many provisions of the law.
Law.
Of the law of the Manual Scavenging Rehabilitation Act, which is not being provided. In fact, requirements of scholarships for children of deceased manual scavengers. Then the issue of having state level meetings. One of the most important issue is that under the Act, 2 state level meetings
Per year have to be conducted every 6 months. Now, from the last 3 years, only 1 meeting per year is being conducted. And in fact, there were orders passed by this honorable court in the past. Even now, they cannot change what they've not complied. We are now in 24 July. Entire year of 24, not a single meeting in the first 6 months is conducted. They now say that they're trying to schedule some date, but one meeting time has lapsed. They now cannot do even 2 meetings in this year.
Yes. Will
My lords, a new day, because in view of the Lok Sabha elections, my lords, we could not conduct. Now a date is fixed. We are going to report to my lords after the meeting what has transpired, my lords. Rest of most of the things,
the meeting is fixed.
my lords, the date is, my lords, I'll just. In fact, the date they have said is some June date. June is also over. We are in July. Some 10th June date is given in one of their documents. That was a proposed date.
Meeting is for what purpose?
I'm sorry, my lords.
Meeting.
My lords, under the law, there's a
Statutory.
state level meeting which is headed by the officiaries, section 26.
Periodic.
In fact, July, normally they do it in January and July, 2 meetings in a year.
The statutory meeting.
These are statutory meetings. I think it is headed by the Honorable CM, by the Chief Minister. Honorable CM heads the meeting. It has to be headed by the Chief Minister. And all the principal secretaries all have to report on the compliance. That is a requirement under section 26. We are in July, my lords.
So you take instruction when
Please.
you're going to.
The next day, I'll give the date, my lords.
Monday,
Please.
May I make one submission?
Tuesday, my lords, 9th.
Tuesday.
9th.
May I make one submission? The connected matters may be disjuncted and sent to the court, my lord. Otherwise, my lord, there is no, lordships ordered last time that compensation payment. So these matters which are unrelated to the core issue, because the core issue needs to be espoused and that needs to be monitored and, my lord, the directions have to be passed. The compensation issue, my lord, if that is satisfied.
Writ petition number 815 on the last date of hearing, my lords, so directed the.
Otherwise, it will disturb the actual flow of the cases that, my lord, that is being argued. Lordship-
That's an individual petition which was actually.
No, it was not DTAG, my lord. Orders were not passed. These are only relating to, my lord, there was an unfortunate instance.
Having regard to the. Issue involved in, this is in writ petition number 815 of 24. Having regard to the issue involved in the present writ petition, juxtaposed with the main proceedings of writ petition number, juxtaposed with the proceedings of main writ petition number 8928 of 2020. In course of the consideration.
And 3211 also, my lord. That is also a PIL. 31.1. Those are connected.
And 30, and writ petition 3211 of 18.
Yes.
In course of the hearing.
Yes, 32.1 may be continued here.
815 has to go before the. Just one. 81, only one.
The others are PILs. They can remain.
31.4, my lords, may kindly be dealing because it's an individual claim.
So we are dealing in 8151.
Please.
Yes.
That's all.
yes.
That's all.
That's all, nothing.
Yes.
Nothing else.
Again, write down. Having regard to the issue involved in the writ petition number, this will be ordered in 815. Having regard to the issue involved in the writ petition number 815 of 24, juxtaposed with the public interest petition, which is the writ petition number 8928 of 2020, and other connected petitions, comma, it transpired in course of hearing while considering the matters, and for which the learned counsels for the respective parties are addendum that writ petition number 815 of 24 is required to be detached with the proceedings of writ petition number 8928 of 2020, and that the subject matter of writ petition number 815 of 2024 is required to be deserves to be dealt with by alone a single judge.
Yes.
Accordingly, writ petition number 815 of 24 stands detached with the other matters. Also, the registry shall list the same before the appropriate bench as per the roster.
My lords, on the, let the government respond on the
On the
state
date,
government
I'll
meeting.
place
my
on
lords.
record the date of meeting, my lord.
As regards the main proceedings, learned advocate Miss, what's your good name?
Jaina Kothari.
Jaina Kothari submits that there have been violations and non-compliance of certain material provisions of
My lord, section 26 for having a state level committee meeting.
including section 26 of which act?
My lords, under the,
Manuals.
yes.
Manual
this is, my
Scavenging
lords,
Act
the
2013.
Prohibition,
Manual Scavenging Act.
prohibition of employment is Manual Scavengers and Rehabilitation Act 2013. I'll give the details, my lords.
Pura act ka naam.
Under section 26.
Learned additional advocate general Miss Onnapura takes time to take instructions on the aspect of compliance or non-compliance.
We'll comply, my lords. I'll place on record the date.
Of the relevant provisions put up on 9th of.
9th, my lords, grateful.
Grateful.
Compliant, not non.
Number 32.
For the petition.
Appearing for the state, my lord.
Seeking for recalling the order dated in IA number 1. I have filed an application, IA number 1.
My lord, I would like to just make one submission over here.
You want to review?
PL was dismissed.
PIL was dismissed.
PL was dismissed.
PIL.
For not attending the office objection.
My lord, I am for the petition in the connected matter, my lord, PAL.
These are the applications. How many applications? One.
There are two, man.
Two matters.
Two petitions.
Two. No. One is mine. Uttara Karnataka, Retiral Abhiruddhi Center. The another is that.
So
35374 of
why should-
2019, my lord.
Two
One
PIL.
petition, one PIL was dismissed, my lord. That is serial number 32 was dismissed for compliance of office objections. Now 32 also is a related matter and it pertains to the respondents taking appropriate steps in transferring
are
9
only-
offices.
Only one IA or two IA?
One IA is for recalling, the other IA is the delay in filing the
Delay in
recalling.
filing.
What happens? The petition itself was dismissed in 22.
So order in IA number 1 of 23. Both are 1 of 23. Two, IA number, order in IA number 2 of 23, with IN number 1 of 23. Common order on full stop. Then heard learned advocates for the respective parties, comma, paragraph. IN number 2 of 23 is for condonation of delay of 291 days, which has taken place in filing the restoration application. It appears that the writ petition, which was in the nature of public interest petition, came to be dismissed on the ground of non-removal of office objections. First of, by the time the restoration application could be filed, the passage of time resulted into delay of 291 days. Full stop. From the averments of the application, the delay could be said to have been explained. Even otherwise, it is right principle that sufficient cause is required to be construed liberally. Full stop. Delay is condoned, application is allowed. As far as IA 1 of 23 is concerned, it contains a prayer for restoration of writ petition number 5563 of 2021, which was dismissed on the ground of non-removal of office objections. Full stop. Instead of, it will be in the interest of justice, that instead of dismissing the petition on the technical ground of non-removal of office objections, the petitioner should be allowed to contest his case on merits and agitate the cause on merits.
My lord, just
which
one
he
submission
is
in the matter.
Espousing in the public interest petition. In that view, the application is allowed and the writ petition shall stand restored to its original file along with all orders which may be subsisting therein.
My lord, just one submission in this matter, my lord. It is a writ of mandamus for seeking the respondents.
If I have a complaint, 2 weeks.
2 weeks, not 2 weeks. On or before 9th.
The entire public interest
Before
litigation.
9th. We'll see on that.
Please.
What is the public interest petition?
This is there are 9 officers. Mainly, respondent 2 and 3, Niravari Nigama, it is a company formed in the interest of farmers. So far, the annexure was issued in the 10/1/2019. Till now, the government order was not implemented. Shifting of the officers from
To-
this
to
Pengu
transfer
to
the office.
different areas.
You're arguing, not telling the subject matter of your petition. We want the subject matter, not arguing only on 9.
Lord, he wants the branches of the respondent officers to be located in
At
Kalburgi as well as in Dharwad.
Per day,
My Lord, there is a notification by the state government.
they-
My Lord, they claim to be a Sangha which is operating, my Lord, Uttara Karnataka Raitra
North
Abhiruddhi
Karnataka.
Sangha.
Ninth will take. Remove whatever objections or not, we'll take up on 9th.
One humble submission, my lord.
You also.
My lord, actually, in this matter, my lord, our matter may kindly be dealing from this matter, my lord. Because of this matter, our matter is getting dragged. Connected matter, my lord, 32.1.
What do you want?
Our matter may be dealing from this main matter, my lord.
That day we'll see.
That is the same issue
Same
also.
issue.
Same
That day
issue.
we'll see. We're not dealing.
Kindly have it on Friday. Objections are ready. The next matter.
Which is next? We're-
33 and 33.1.
Green bench. It is
Green bench.
Mining,
Mine.
Friday,
Friday, ma'am. Objections are ready, or next week.
Monday,
Okay.
but not Monday, then
10th,
11th,
Oblige.
11th.
let him
It
send
was
a
early.
copy in advance so that I can.
You copy.
Yes.
It was earlier argued,
No,
Not
no,
argued.
No,
not.
Not argued.
11th,
Oblige.
Great.
after recess.
Yeah.
Item number 36, seek for a short accommodation to file a rejoinder.
33,
My lord,
33,
36.
36.
36, my lord, I am appearing. 36, my lord, I am appearing for the bank. The property has already been auctioned. We have realized about 22 crore 65 lakhs rupees. And the lordship has granted an interim order for a temporary period.
This is that counting of continuous service, same. He was not in service since 86 to 93.
But the problem now, my lord, is the.
You are for
But-
whom, madam? My appellant. Let it be. 22nd, 23rd July.
But now, my lord, the auction purchaser, now he is insisting for refund of his amount.
No, no,
because-
auction is not, it is gratuity matter.
No, my lord, it is, my lord, this is in respect of, my lord, the bank has auctioned the property.
This relates to my lord, the auction of a property. I am a mortgagee. I am the appellant in the matter.
Serial number 36.
So, my lord, on 9th May, there was an interim order granted. That, my lord, is now, we have also filed a separate application to which they filed objections to it. We need to file the journals to bring certain facts on record. This is why we're asking for a very short accommodation.
All right. When shall we keep?
My lord, any day that is convenient.
Our problem is auction purchaser is insisting for
Same
refund of
date.
amount.
Same date.
10th.
23rd July.
Until we, if it is possible, Raj, may kindly have it next week, madam, possible. 9th or something. 9th, if it is possible, madam, because
9th is lot many matters. We are afraid of 9th now. So many matters are there.
at least any date and.
Everybody says 9th, I don't know why.
No,
Because
really.
it is 9th.
Any date.
Not
It-
possible.
At least
In
some.
sum and substance, not possible.
At
So many
least
matters are
in some, I mean, at 2:30 and some days you will ask me kindly fix because
Take chance on 16th.
2:30 you will ask me kindly copy. Please.
Interim order may be extended.
It will be extended.
Please.
Milord, serial number 64, Milord. Milord, serial number 64, Milord. I'm for accused, Milord. Kindly give me short accommodation to comply my office objection.
Office object. All 3 weeks.
Serial number 9, passed over, my lord. I sought the papers to the Mr. Jaggi, my lord.
A week's time maybe, granted, so that I will get the information.
What is that?
The PL matter, my lord. In morning
Serial
it
number
was
9,
passed
my
over.
lords.
Yes, that construction.
Yes, my lord, a week's accommodation, my lord, so that I will get the information and make the submission. By Friday, if not by Monday, my lords.
Acha, yes.
Yes,
So
I
you
can't
are-
with my
Not weeks time, it is little bit urgent therefore. You take instruction.
Friday, my lords, Friday, if not Thursday.
Friday or Monday, Monday can.
Please,
8.
please, my lord.
You have left the construction incomplete.
Yes, my lord.
So it water and.
Yes, my lord.
That is the only thing. It is
Yes.
ultimately your domain, but still we are
Yes.
taking interest.
Petitioner.
This is a contempt against the interim order, your lordship. The allegation is that they have executed the sale deed. The owner of the land has executed a
We
sale.
are slow in dismissing the interim order contempt because there are
Yes.
judgment on both the sides.
Yes, sir.
Therefore, you must be noticing that we become slow in this.
But I am the owner of the TV channel. There are two appellants, my lord. Appellant number 1 is a service provider to appellant number 2. The cost title is at page 5, my lord.
Which order you are challenging?
Yeah, the impugned order, my lord, is at page 17. The text begins at 18.
That is dated
Yes, last portion.
25/6.
Yes, my lord, 25/6.
Correct.
Kindly go to para 7 of page 18.
Yes.
Under these circumstances, in the light of undisputed fact that proceedings have been initiated by Union of India pursuant to the final show cause notice dated 9/2/24, it would be just and appropriate to direct respondent 3 and respondent 5 and other private respondents not to continue with any broadcasts and restrain all private respondents from carrying on any broadcast activity till next date of hearing. Now, I'm a channel, my lord, operating. I have applications filed for renewal of my license. There are two types of license that are needed, my lord. We need approval for telecast port and we need approval for uplifting. Now, I have applications for uplifting. The latest approval I have, my lord, your lordships will get it at page 223.
220.
Yes. (19/3/24). This is regarding the change of frequency issued by the Government of India. Subject endorsement, de-endorsement of TV channels along with uplinking permission through teleport of Lamha satellite so-and-so under license number so-and-so. With reference to online application dated so-and-so of Lamhas, the following TV channels are hereby endorsed along with uplinking permission in their teleport tower number so-and-so acquired by license, which is valid up to 39/24. Last name them, not number 3 is Power TV, a station which belongs to the second appellant. Uplink frequency is changed. Then, my lord, please go to page 221.
So this is what license.
Yeah, this is, my lord, page 223 is approving the change of the frequency. Your lordships may notice there's a change in the frequency there. Third column, 6381. And they've given us new frequency of downloading, 4156. And last column says purpose new TV channel. Then, my lord, please go to page 221. This is also as late as 5/3/24. Communication from the Under Secretary to the Government, who is respondent number 1 in this appeal, to the Managing Director, Midcon Infra, which is second appellant, which according to me is the owner of the channel. Application for change of teleport from Information TV Private Limited to Lamhas Satellite and uplinking downloading of TV channel, namely Andy Haryana Power TV Midcon Infra Project Private Limited. I am directed to refer to your 2 online applications bearing number so-and-so, dated 31/23, received on Broadcast Seva portal and the above mentioned subject, and to convey permission of the Ministry to Midcon Infra Project Private Limited in respect of TV channels, namely Andy Haryana and Power TV for the following changes.
So you're a multi-state operator.
Yes, I am a multi-state operator and I have, my lord, in more than one language. And I have all permissions that are needed. This is the latest permission that is given. Now, my lord, what happens is, that's why, my lord, I pointed out in the morning, the prayer in the writ petition, my lord, is, your lordships may now see, my lord, the request made on 4/3/24 by the complainant. Your lordships will find it at page 142.
Writ petition. What
This
you're-
is a memorandum submitted by the writ petitioner to the Government of India. Subject requesting action against TV Kannada channel. Then he refers to, well, several complaints. Then he says at page 144, all his previous complaints he refers to. In para 8, he refers to the earlier permissions that were granted. And page 145, my lord, para B, he says this Power Smart Media Private Limited, which is first petitioner. What he's trying to confuse is, he's trying to insinuate that the channel is run by the first petitioner. Whereas that is completely contrary to record, which I have submitted to authorities. There's an agreement between the owner of the channel, who is the second appellant, and the first appellant. The first appellant is providing services to us. There are several types of services they give us. There is an agreement, signed agreement, to submitted to authorities. Accordingly, they are collecting the revenue and we are sharing the revenue and paying them charges for it. All of that is documentation is available. But he tries to make it appear that this channel is being run by this first appellant. That is the mischief. Then Lord para 9, he says, this Power Smart Media is not issued any license.
It is a misunderstanding. What is mischief in it?
Mischief is that he is trying to portray that the first appellant is the owner of the channel, when really everybody knows that it is not the owner of the channel, it is only the second appellant who is the owner of the channel.
Who is first appellant?
First appellant, my lord, is a company called
No, what is the status of that first appellant?
it's a limited company, my lord. It is engaged in the business of providing services to TV channels. It has studio, it has some personnel, it has equipment, and we are hiring them. There is an agreement. Your lordships may see the agreement, my lord, that we have entered into. We have produced a copy of that agreement.
So this Messrs. Power Smart.
Yes, Power Smart is a company, Media Private
Why
Limited.
is one of the party? He is not related to anything.
It's not related to me.
No, not related to any controversy, it appears.
Yes, but that's what I'm saying. The mischief is they are a respondent to the petition, and they are made a respondent alleging that that company is running the TV channel without a license, so you stop it. Whereas all the records indicate that the company which owns the channel is not this Power Smart, but it is this Midcon Infra. All the correspondence, everything, my lord.
What do you have to say about this?
Let my learned friend complete.
Textual all that. Yes.
Then, my lord, with all these documents, my lord, are placed on record by us. We produced a copy of the agreement also, my lord, under which we have entered into agreement for services with this company. Your lordships could kindly peruse that at 201. I have not troubled your lordships reading all of it, my lord, but just show your lordship that there is an agreement between the two companies, what services they have to provide, how much we have to pay them. And I've also produced a statement of account which shows how much money we have totally that has received, how much has been paid to them, what are the taxes paid, GST, everything is there. And all the records of Government of India show that this channel is not run by Power Smart, it is run by Midcon. That's why I showed the last two letters, my lord, March 24 onwards. Both of them are referring to Midcon, and I am the owner of the channel, that's the second appellant. Now, my lord, in this state of affairs, he gives this representation to say that some illegal things are happening. His main grievance, my lord, is that we aired some program, which he says is defamatory, it's in bad taste, and he has initiated proceed against me, which is going on in a different forum. Based on that, he goes to government, gives a representation, and he now comes to court saying that my representation was considered. Please direct them to consider. The learned at the hearing, my lord, what they do, across the bar, they suddenly produce a document which they say is a show cause notice issued by the government of India to the second appellant. That is not part of the record, no pleading, no averment. That show cause notice is 9th of February 24. The writ petition is filed several months after that. And we had no opportunity to say anything about it.
They have produced.
Now, my lord, yeah, they produced across the bar. The learned judge looks into that and says, oh, they've issued show cause notice. So we'll stop the channel. Even in the show cause notice, they don't say that we will stop your broadcast. Your lordships may now permit me, my lord, since they didn't make it part of the record, I could not have filed it in a part of the writ appeal. I filed an application, my lord, which contains that notice. Your lordships may kindly peruse that notice, my lord. IFF 4127, page number 8. In February 24, we received the notice.
Page number?
8 in the IA. It's marked as document number 1. It's dated 9/2/24. It says final show cause notice. Midcon Infra Project Private Limited, that is the second appellant and owner of the channel, was granted permission, YD Ministries letter dated so-and-so, to uplink and downlink a news current affairs TV channel, namely Power TV, in accordance with the then policy guidelines for uplinking, downlinking of satellite TV channels in India. Permission was valid till 12/10/21. Company applied for renewal of permission YDE application dated so-and-so 30/12/22. Same is under examination. Then, my lord, there is 3, 4, 5 issues about content generation, number of things. I will not trouble your lordships, my lord. Kindly go now to page 14, my lord. Therefore, to examine the matter further, you are hereby requested to furnish the following documents and information to this ministry. Long list. And finally, at 15, you are given a final opportunity to furnish the required documents and for personal hearing being granted on 19/2/24 at 12 noon in the chamber of so-and-so, to show cause why action should not be initiated as company for violation of conditions of permission, including clause 80 and 30 of the policy guidelines. Request to furnish the information on or before so-and-so. I have, my lord, submitted detailed reply. I'm not troubling your lordships, page 16 onwards. All the replies on each point, I have submitted a reply. Till date, no order is yet made by the ministry.
What happened on 24/2, 19/2?
19/2, my lord, the matter was heard. Documents are produced. And they have still not, the rule requires, the guideline requires that once they hear, they must pass an order. No order is received. So this order, my lord, the learned judge was actually misled, my lord, by producing this without producing any of the replies, and we had no occasion to deal with it. Learned judge says, oh, show cause notice is issued, therefore we'll stop the telecast. And the change of teleport permission, my lord, your lordship just now saw that is in March. This show cause notice in February. They have raised that you give us this information. We are given the information.
Interim order was passed pursuant to some application.
No, pursuant to the prayer in the writ petition. The interim prayer in the writ petition is direct respondent 1 to shut down my channel. That's a direction sought to the government. They have not yet done anything. But the learned judge says, stop the channel. Operative portion of the order, my lord, is at page 18. My lord, let the writ petition be heard, my lord. The state, the central government has to take a stand. It can't be that the law officer will just stand up and say, we will do whatever we have to do. They didn't file a statement on oath. Based on this notice, please see, my lord, learned judge extracts that notice at page 18.
Where is this 4324 complaint?
That, my lord, your lordships will get at page 142. Begins at 142. The concluding prayer is at 146. He, my lord, alleges so many things.
What is 43?
And this is being inquired into. I have replied to the notice issued by the government.
This Power Smart and this other company.
Midcon.
Directors are same.
No, they're not same. It's an arm's length agreement, my lord. The agreement copy is produced. Now, before the government can take any action, if they have power to take action or not, they can take action.
But in this complaint, there is a mention about you not having license.
He says that, my lord, that is what I'm saying. My lord, he says, I don't have license. And he says, government requests the government to take action. Government issues me a notice, has not yet passed an order. I can understand if the government, my lord, passes an order. Now, my lord, if he comes to court for a mandamus, to say, consider, even in the main writ petition being allowed, relief granted could be to direct them to consider within a time-bound frame, if that is so required. But it can't be that before that adjudication takes place, the honorable court will say, you stop. And after the initiation of proceedings, other permissions for uplinking and downlinking are given to us. As late as March. All under the same rules and guidelines. The prayer at page 146 is direct them to take action, consider my representation. Prayer in the writ petition is also that. Now, my lord, please see the order, my lord, passed at page 18. Para 2. In addition to reiterating various contentions urged in the petition and referring to the material on record, learned senior counsel in both petitions invited my attention to the earlier interim order passed by this court in order to point out that despite proceedings already having been initiated by the central government against respondent 3 and 5, the said respondent, along with other private respondents, are continuing to broadcast without obtaining necessary approval, renewal of approval. As such, necessary directions may be issued to the said respondents not to continue to broadcast without obtaining necessary approval, renewal of approval, which is illegal contrary to law. And necessary directions may be issued to the private respondents, restraining them from continuing with their said illegal activity. This is not even the prayer in the petition. My lord, a counsel is bound to argue what is there in the petition. He can't add something which is not there in the petition. The petitioner didn't seek for that relief at all. He didn't say stop the channel. Then, my lord, learned so-and-so appearing for respondent submit that the proceedings have already been initiated against respondent 3 and other private respondents. They have entered appearance in the proceedings which are pending consideration. It submitted their final show cause notice of 9/2/24 has been issued to the union to respondent 3 and 5, who has received the same and is contesting the proceeding. Now, this submission that is made is again, my lord, an off-the-cuff submission because the writ petition is silent. If they were aware of this, my lord, on 9/2/24 that a notice was issued, they were bound to plead it. They were bound to say that such a notice is issued and this is the purport of it and produce the document. They don't do it. They just pull it out of the pocket and hand it over to the judge at the time of hearing. And interestingly, if they had this document, they would have the replies also. I am taken by surprise. At the date this matter is being heard, it is just given. Then, my lord, please see, next para is extract from the show cause notice. That itself shows that the matter is still under examination, my lord. May I read that, my lord? Messrs. Mitcon was granted permission YD Ministries letter dated 13/10/21, 2011, to uplink and downlink a news and current affairs TV channel, namely Power TV, in accordance with the then policy guidelines for uplinking and downloading of the satellite TV channels in India. The permission was valid till 12/10/21. Company has applied for renewal of the permission. YD date 30/12/22. Same is under examination. Now, my lord, I have given a list in my application. All TV channels, my lord, in India, I have given the complete list. All of them are operating without a renewed license. Government, my lord, when you make an application, they are not rejecting those applications. All the channels are working. And they give us the uplinking permission. That is what is crucial, my lord. And that consistently they're given. I only showed your lordships 2 of them, but from 2021 till now, they have consistently given us. We wanted a change of name, they gave us. We wanted change of teleport in 2019, they gave us. Change of name from Power TV to ABN to Power TV, that is granted by us in 2019. Now, in a situation like this, my lord, my learned submission, my lord, is this. At para 4, learned judge refers to this permission that was granted, my lord. Learned so-and-so invited my attention to Annexure X, dated 6/2/24, in order to point out that the central government has addressed a communication to the director of respondent informing them that Power Smart Media Limited is not a permitted company from the said ministry in relation to uplinking, downlinking of TV channel. My lord, this is also, my lord, a complete misreading, my lord. It is not nobody's case that this Power Smart Media is the one which is doing this. That is not doing it. It is in Mitcon which is doing it, which has all the clearances. And they write a letter like this. They know it. Its record of the government itself shows that. They are corresponding with Mitcon only. It is therefore submitted by the learned so-and-so that till completion of proceeding initiated by them, respondent 3 and 5 and other private respondents would not be entitled to continue to broadcast. But how can a counsel say that, my lord? It's not the client's case. It's not their affidavit. It's not their submission in writing. It's not their order. It's not their decision. Their notice says it is pending consideration. And if a counsel, my lord, stands up and says, please ban them. Yes, that's all. Chinnappa, yes.
I'm in the second matter, 24.
What is that?
Same issue, Mal, same issue. I only want to add 2 points.
Another channel.
No. Same channel, 2 petitioners,
Another
2 petitions.
Another channel, another program. What is the difference?
No, there's no difference.
Two victims. No.
No, my lord, there are 2 complainants, basically 2 people with grouses.
2 complainants.
2 complainants in the sense, we have telecast programs not about specific individuals. In my case, it's a member of the Legislative Council
In my learned friend's case,
Effect of the order is same.
effect of the order is same. But what I'm only pointing out is your lordship must examine this from the point of view that the person who's coming and complaining is a person who has a grouse against the channel. It is not someone, Lord, who has some great public interest in mind. He is coming and attacking a television channel for the simple reason that there's been a communication to the public about something that he has done. He has sued the channel, my lord, in various places. He has filed a criminal case, he's filed a civil case, his defamation, all of that is there. Then he comes and makes a prayer before the court. At best can only be to consider his representation which he has made to the ministry. It can't be, in my respectful submission, Lord, the power being exercised by the court itself. In my respectful submission, what is now being done is, if the ministry is the one which is entitled to exercise the power, at best, my lord, your lordships have always held, it is a direction given to the appropriate authority to take action in accordance with law. Can that power now be exercised by the court? And said, the authority will not exercise it, we will exercise it. And that is precisely what has now been done. By virtue of this order, my lord, the Honorable High Court has now said that the authority will not exercise that the power vested in it. I will exercise that power vested in it. Now, my lord, I only want to add one more point to what my learned friend said. If you lordships look at page 18. At best, my lord, the court could have said, ask the union to take a decision immediately. Maybe the next 48 hours, 1 day, 2 days, whatever it be, if there was such a gross violation. And I only want to point out one thing. Your lordship saw the show cause notice, Lord. The show cause notice refers to the fact that in 2021, my renewal application is pending. It has not yet been considered. Now, if that was correct, that without a renewal, I cannot operate, then not the first statement which would have been made in the show cause notice, how are you operating? That is not said, because the central government is conscious of the fact that every television channel which applies for permission goes through this process of examination, and ultimately permission is granted or refused. Until the refusal is done, the television channels continue. And I've produced not a list of channels in India, including Bloomberg, BBC, all of whom are under renewal applications now. Everywhere it is the same thing. Now, if the center knew that my permission for renewal is pending and points out various other deficiencies for which I am asked to respond, can it today be turned around and argued by the other side that he doesn't have permission and therefore the court must step into the shoes of the union and stop this channel?
What is the status of show cause notice?
I have responded, there's no decision.
There are 4 replies that have been given. I have produced copies of all the replies. Whatever documents they wanted, I have produced all of them. They wanted balance sheets, they wanted proof of payment, they wanted how the money is paid, what is the adjustment that is there, how the employees are employed, who pays the salary. Individually, questions were posed, all of that we have answered.
I'm not, please see the complaints at page 174 and 176 in my petition, in my appeal note, I'm sorry. At page 165, my lord, one of the complainants writes at page 165.
So the grievance in both the petitions is about same telecast.
May not be the same telecast, different programs, but the issue is the same. Their entire grounds are simply that they are telecasting things about them which are improper.
So
and says take action.
Which page? 174.
Yes, my lord. This is a complaint, my lord, 174 and 176 from the a request to take action specifically.
Being examined.
Once. And that is considered and responded 178. And that not the Minister of Information Broadcasting responds saying, I'm considering it, it's under consideration. When all of that is under consideration before the ministry, which is the authority, can I ask myself, Lord, can the learned single judge on a request made by them on the show cause notice turn around and say, I'll now stop the broadcast? At best, Lord, it could have been, even if the writ petition had been allowed, it would have simply been a direction to the Ministry of Information and Broadcasting to consider the show cause notice as well as the representation and pass an order in accordance with law. We'll then, my Lord, go through the process and challenge it if it is against us. But this, my Lord, in my humble submission, we were, of course, completely taken by surprise by the fact that a document was handed over in court without giving us a chance to respond to it.
So this license is issued under which law?
Beg your pardon, my Lord? There are, my Lord, yes. My Lord, the guidelines for uplinking and downlinking of satellite television channels in India, 2022. There was a 2011 guidelines, which, my Lord, has been superseded by the 2022 guidelines.
Is there page 90? 22 guidelines are there in my petition,
It's
the
in
other
mine
petition which I argued, my lord. It's at page 148.
94, page 94 in the same petition.
Some guidelines, policy guidelines.
Policy guidelines.
There is no statutory statutory
94 page 149.
in which petition?
In the
First,
first.
No, in the second one, it's at 94.
yes.
My Lord will see at paragraph 4 is the concept of grant of permission.
This is for teleport. Part 2 is for teleport.
Yeah, first is the permission.
Part 3 is for channel.
Uplinking of television channel, my Lord, is part 3.
It doesn't have any statutory origin, this guideline.
This is framed under the Telegraph Act,
Telegraph, right? That is what I'm asking.
Section 4 of the Telegraph Act.
Yes, anything?
That's it, Lord. My respectful submission, therefore, is the court could not have passed this order. 21. The teleport permission, Lord, is given under 21, under Rule 21 or the paragraph 21, which was granted in March of 2024 after the issuance of the show cause notice. The reference to the show cause notice is that your application for renewal is pending, as your Lordship saw in the first paragraph of the show cause notice. Then paragraph 21 is for change of satellite or teleport. That teleport permission is given to us.
So this order 25/6/24 is common order
Common order.
in both petitions.
Identical order. Identical order. Identical order.
Identical separate order,
No, my lord, it's one order. One order. Common order. It's a common order.
not common order.
No.
Two orders separate.
In both the petitions.
Maybe identically worded.
Identically worded, but in both petitions, it's
Separate order.
it's replicated. Your Lordship may see, I'm so sorry. I'm so sorry. My apologies, my Lord. I'm so sorry. Page 112 of my petition, your Lordship will see that change of satellite or teleport. $112. That is, my Lord, what was granted on 19/3/2024. The company or LLP, having permission for uplink a channel, shall apply for change of satellite or teleport on the broadcast seva portal by payment of processing fees. And it is after this that, my Lord, that permission is granted in March of 2024.
Granted.
It's granted. That is what my learned friend pointed out to your lordships on 19/3/2024, that teleport permission is granted, though the show cause notice is issued in February of 2024. At page 226. I'm brief.
Lord, a couple of relevant terms and activities need to be understood before I make my submission. Lord, a TV channel can be broadcast in two ways. One, through the satellite TV channel. The other one is streaming through the web. For these activities, there are two activities involved. One is uplinking, the other one is downlinking. The satellite beaming is through the satellite, obviously, and the other one, the web streaming, is through a teleporter. That's very important because I heard my learned friends repeatedly say that they've got a teleporter license.
Teleporter.
Teleporter, 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 P-O-R-T-E-R. Teleporter, my lord, it's a defined term.
So what is the teleporter?
Teleporter.
What is teleporter?
But there is a definition, my lord. Could your lordship now graciously turn to page 149 in WA 949 in the first writ appeal? Lord, may I take your lordship through the policy guidelines. Page 149 in writ appeal 949.
Earth station facility.
Yes, my lord. So teleporter means an earth station facility from where multiple TV channels carrying audio video content can be uplinked to a geostationary satellite on permitted frequency band with due approval of WPC. WPC means Wireless Planning and Coordination Department of Telecommunication, at the bottom. So therefore, if I'm someone who has the content to broadcast, and if I want to broadcast it on the web, I will need the services of a teleporter. I will have to identify a teleporter. I have entered into an agreement with him. And to my ministry, MIB, the broadcaster will have to disclose who is the teleporter with whom he has entered into an agreement, through whom this will be telecast. My lord, that is the definition. For the teleporter, there is a separate license, which your lordships will see at para 3 of the policy. My lord, I'll not go to read that, but part 2, para 3 deals with the license for the teleporter. The license for uplinking can be found at para 6 of the policy, page 153. Lord, this is relevant, so I will read the first paragraph. Page 153, Lord, in the policy, they call it as para, which can be a rule. So para 6, titled as Furnishing of Application. A company or an LLP may apply online on broadcast seva on payment of processing fee specified in Appendix 1, separately for uplinking a news television channel and uplinking of a non-news TV channel from a teleport and satellite, as case may be in the application, subject to the fulfillment of the following condition. So therefore, the uplinking permission could be either through a teleport or a satellite, but for that, an application needs to be filed, and granting of that permission is under para 7, which is page 154, which says the ministry shall, preferably within 30 days of receiving clearance and approval of Ministry of Home Affairs, because there is a security issue involved here, which is why approval of MHA is required, and other authorities, and after satisfying itself that the applicant company or LLP is fit for grant of permission, issue a letter of intent requesting the company stroke LLP to pay the permission fee for the first year, furnishing bank guarantee as specified in so-and-so, and security deposit. And then it says how to grant it. Now, what is relevant is the renewal at para 9, page 156. Generally, it is granted for a period of 10 years. Assuming that has lapsed or that is going to lapse, Rule 9 says, a company LLP which is given permission under para 7 may apply for renewal of permission at least 3 months prior to the end of the month in which the initial permission is due to expire, online on the broadcast seva portal on payment of processing fee specified in Appendix 1. Lord, para 10 onwards, is the same one, but regarding downlinking. What we saw between para 6 and 9, which pertains to uplinking, we have between para 10 and 12, the downlinking, the similar procedure. The renewal at para 12 also says that you have to make the application within 3 months prior to the expiry. Now, my lord, now kindly turn to
Telecast is connected by downlinking or uplinking?
both, my lord.
What
both.
is that? What is that?
But there has to be
You are at all technical thing, but
True,
it's
true,
not.
right. The signals have to travel both
Signals
ways.
to travel.
It has to travel both ways.
The broadcaster will uplink it.
Provisions must be identical
Yes,
in this part 3 and part.
yes. For example, if we take the case of a TV channel, there has to be uplinking to the TV, the satellite, and then it has to be downlinked onto the receiver and then linked to the TV channel. No, but this is broadly the status. So therefore, to sum up the policy guidelines, there is a teleporter, he needs a separate license, and then to uplink and downlink, you have to make an application, and then it will be granted within 30 days after a whole lot of verification. Upon expiry, before 30 days, the application has to be made. Now, my lord, please let us look at the permission which was granted to the second appellant Mitcon. My lord, that is available at page 192. Page 192, my lord, is the permission which was granted on 13/10/2011 by the first respondent ministry to the second appellant Mitcon Infra Project Private Limited. Page 192, dated 13/10/2011. This is with reference to Messrs. Mitcon Infra Project Limited application dated 19/3/2011, seeking permission to uplink 2 news and current affair channels from India and subsequent correspondences in this regard. The undersigned is directed to convey permission to Mitcon Infra Project to uplink 2 news and current affairs TV channels, namely Lok Shahi and Lok Shakti in English, Hindi, and all other regional language in digital mode. Lord, what follows is very important. Through teleporter, he is named Messrs. Noida Software Technology Park Limited, located at Gautam Budh Nagar, Greater Noida, using INSAT 4A satellite for a period of 10 years, in accordance with the guidelines for uplinking from India notified on 2/12/2005, subject to the following conditions. So, my lord, I would emphasize on the naming of the teleporter, that is one Messrs. Noida Technology Park Limited at Gautam Budh Nagar, and the satellite's name is INSAT 4A satellite, and the period is 10 years from 13/10/2011. And these are all strictly, my lord, time-based. So the first submission that I would make is, with effect from 12/10/2021, Mitcon has no license. The permission granted on 13/10/2011 has expired on 12/10/2021. If Mitcon has carried on any broadcast, it is contrary to the law, it is illegal. I would also point out that 3 months prior to 12/10/2021, no application was filed by Mitcon second appellant for renewal in terms of para 9 and para 12 of the policy. But yes,
1 year and 3 months later.
And he makes the application about 6 to 9 months later.
1 year and 3 months.
Sorry, 1 year and 3 months. 1 year and 3 months. No, my lord, thereafter, a couple of developments took place. Would your lordship now turn to page 197? Page 197. An application was made by second appellant Mitcon to change the satellite, the teleporter. Lord, that is available at page 197. We gave the permission on 22/1. Lord, page 197, if your lordship would kindly turn to page 197.
197, yes.
Lord, kindly have a look at the subject. Permission for change of teleport and satellite to uplink, downlink 2 TV channels, namely Kushi and ABN, Lord, earlier known as Lokashahi. Lord, the earlier 2 names were changed. It says, sir, I am directed to refer to a letter dated 29/2018 on the above subject, and to convey permission to this ministry to Messrs. Mitcon Infra Project Private Limited in respect of your permitted TV channels, namely Kushi and ABN network, for the following changes. Change of satellite. Old was INSAT 4A and the new is GSAT 17. The change of teleport. Old was Noida Software Technology Park. New one is Messrs. Information TV Limited. These changes are in partial modification of this ministry's letter of even number dated 13/10/2011, and all of the terms and conditions of that letter remain the same. You are also required to provide professional, that may not be necessary. So what happened under this letter of 22/1/2019 is merely permission was granted to change the satellite and the teleport. Now this again was once again much changed. And then, my lord, now would your lordship turn to page number 221. There was a further change of the satellite and the teleporter. Page number 221, dated 5/3/2004.
This change in teleporter and change in
5/3/2024, not 2000.
change in this satellite and change in teleporter is a ground to issue notice to.
No. This is routine. We have no difficulty. The satellite and the teleporter are the carriers. It's like a carrier. You need a vehicle to carry.
Only you are showing the peripheral facts, nothing.
True. It is like changing. If I have given permission for someone to engage in transportation, he has to declare which car he is using. He may say, I will today use one car and today use another car, but he has to report to me. Without taking my permission, he cannot change the car. Similarly, for uplinking and downlinking, originally he said Noida Software and INSAT. Later he changed to GSAT and information. Now there is a third request. The third request is, to change from existing is Information TV
Page.
has gone to Lamhas.
Page
Number 221.
221.
221. A letter dated 5/3/2024.
Yes.
Subject, application for change of teleport from Messrs. Information TV Limited to Lamhas for uplinking and downlinking of TV channels, namely so-and-so, so-and-so. I am directed to refer to your 2 online applications dated so-and-so, received on Broadcast Seva portal, and to convey permission of this ministry, namely so-and-so, in the following changes. Now, what is the permission granted? It is only for change of the teleport and change of satellite. That does not constitute a license under para 6 or para 10. So as on today, my lord, the second appellant does not have any right to carry on any business. And the first appellant is picking back. My lord, I don't even know what is their understanding. It is a subject matter of investigation. My lord, we will take a decision soon, my lord, and we will convey to the parties. Whether, my lord, what is the relationship? My lord, today, the first appellant claims that he is only a service provider. But I have received complaints that he has the whole lock, stock and barrel, everything has been rented out to him, which will be a violation of my permission. I will investigate. My lord, if it is mere service provider, that may be permissible. But anyway, that is a subject matter of investigation. But the fact of the matter is that the second appellant does not have a permission under the policy guidelines with effect from 13/10/2021. So therefore, my lord, dehors the order of the learned single judge. The appellants do not have a right to carry on the business. Lord, today, before your lordship, they must demonstrate what is their legal right to carry on the business. They admit that the earlier permission granted has expired. Their only contention is that this letter dated 5/3/2004 constitutes a deemed license. Now, merely because I permit them change of teleport, maybe in anticipation, teleport and satellite, that does not mean that I have renewed the license, which is still pending. The license application is still pending before me. Lord, I am going to take a decision soon. The question is, my lord, today can the appellants claim a right to carry on the business? My lord, my respectful submission is, my lord, they do not have any right. Lord, the learned single judge, my lord, was not right. Please have a look at the order. Page 18, my lord, of the paper book. Page 18, my lord, is the order of the learned single judge.
Order of learned single judge.
Somewhere in the center, my lord, learned judge reproduces the show cause notice. Somewhere in the center.
Yes.
Final show cause notice. Mrs. Mitcon was granted permission by this ministry's letter to uplink and downlink a news and current affairs TV channel, namely power. Not page 18.
Same order.
Oh, I'm sorry. I'm sorry. And then, my lord,
Font is so small that.
I'm, I'm sorry. My lord, the last sentence in that extract, it says, my lord, the permission was valid till 12/10/2021, and the company applied for renewal of permission by application dated 30/12. The same is under examination. My respected submission is, learned single judge went by this content of the notice. He notes that the permission was valid till 12/10/2021, which is why he said, don't carry on the business.
But they are saying that without pleading, without application, without.
Oh, my lord, the appellant was aware of the show cause notice. It may not have been produced by the petitioners, but the appellant not only was aware that he has participated, he has appeared before me. I have granted 3 hearings, my lord. He appeared in person. There have been 3 hearings, my lord. The last hearing took place on 16/4/2024. They have filed reply. They have filed annexure documents. In fact, the appellants have graciously produced all those documents. In essence, my lord, the essence of the single judge's order is that the respondents, my lord, did not have a right to carry on the business.
Notice issued to appellant number 1.
Yes. No, it applies the relief. Let us read it. And the show cause notice is to appellant number 2. I'm sorry, I didn't get your lordship's question.
2.
The notice is to appellant number 2.
Bitcoin.
Yes. Because he's the one who has applied, who has made the application for renewal.
They are saying that Bitcoin has everything, license, this.
No, where is the license? They also admit that it has expired on 12/10/2021. Their claim to carry on the broadcast business is the letter of 5/3/2024, which is a permission for change of teleporter. Now, change of teleporter by no stretch of imagination constitutes a permission to uplink and downlink granted under 6 and 9 of the policy. So, single judge, my lord, influenced by the undisputed fact that the permission was valid only till 12/10/2021, has issued an order of restraint. My lord, what is wrong in that? Admit, my lord, this is an admitted fact. The fact that the permission was valid till 12/10/2021 is an admitted fact. Based on the admitted fact, he says, don't carry on business. And moreover, my lord, that order is only till 8th, my lord. On 9th, there is a hearing. My lord, I'll file my objections. There may be a direction to the single judge to hear all parties and dispose it off finally. I will complete my pleadings before 8th. Please look at the last 2 lines, my lord. And restrain all private respondents from carrying on any broadcast activity till the next date of hearing, released on 9/7. Lord, I'll complete the pleadings by 7th. Lord, the single judge may hear all parties and dispose of the writ petition itself.
Yeah. Even if it is allowed, it's a direction.
I have no objection to the writ petition being allowed as prayed for, my lord. I have no objection for the writ petition being allowed as prayed for in the petition. The direction to consider, let that be ordered. I have no difficulty.
That's it.
But whether this order can stand is a question that arises.
No, if the writ petition is disposed of, where is the question of this interim order? Then, my lord, the next question is whether the appellants can carry on the business. My lord, they cannot.
That you take action.
Well, my lord, that statement may be recorded. If my learned friend says you take action,
if it is withdrawn
it's recorded
before your
statement,
lordship,
my lord, I will take action.
and the writ petition, my lord, he doesn't need my certificate for taking action.
No, if there is a submission made
What
at the
I'm
bar,
submitting
kindly
is
record it. I will take action.
that if the writ
I
petition
don't
is
need that.
withdrawn to your lordship's, my lord, and the writ petition is allowed as prayed for.
Are you sure?
Yes, my lord. Prayer is to consider.
Prayer is to stop.
Read this.
That is exactly I'm pointing.
In my writ petition, my lord, in 949, the prayer is to
Now you
consider.
don't repeat that it may be allowed.
and
Stoppage of broadcast.
consider.
No, no, not consider.
That's in my writ petition. In 951, there's a different prayer.
No, no, Mr. Nagananda wants his petition to be.
And consequently take action. That taking of action is a direction which they can.
By stopping.
That
So we
that
will do
is,
that.
that can't be granted now.
So that's the point.
It's, the prayer is to consider that.
Senior counsel is not permitted to resile from the statement. Anyway, this is in lighter. way. Yes.
My lord, that is all I have to say.
You are for-
appear in sorry. But I appear in 951 of 2020. But I am a member of the Legislative Council against whom, my lord, there were certain telecasts which were defamatory, all far from the truth. False and fabricated news were circulated. But I have initiated action against this television channel. Matters are pending. Meanwhile, my lord, I was informed.
Who are you?
I'm a member of the Legislative Council against whom, my lords, certain news reports were circulated in their television channel.
You impleaded some subsequent.
I'm a writ petitioner. I'm a writ petitioner. One of the writ petitioner.
That professor or police officer?
I'm a member of the Legislative Council,
He's the politician.
MLC.
One is police, other is professor.
No, member of the Legislative Council, MLC.
In Mr. Chinnappa's petition.
Yes, in that matter.
Professor, my lord, is the name of the lawyer, which your lordship saw in the legal notice. That Professor Rangaswamy Law Chambers is the name of a lawyer, not the petitioner, my lord. The lawyer for the petitioner.
I thought petitioner is a professor.
No, he's not a professor.
Just cursorily I was.
There were several news circulations made against me. But I'm a victim of those false news, etc. I have initiated proceedings. But I gave a complaint to the ministry when I came to know that this Bitcoin, lords, was only a front company. It did not have an office. It was, in fact, not in the infrastructure business. And what it did was, after obtaining this permission, it let its license out to the other company, namely that is Power Smart India Limited, for operations. That is essentially my complaint. In the writ petition, Lord, I have brought out several facts as to that there has been no license which has been granted to them, the persons that is Power Smart India Limited. When the matter was being heard, Lords, there was a direction earlier to this order of the learned single judge, which I must bring to Lordship's notice. May I request Lordships to kindly see the earlier order, which is at page 17. Page 17, the order passed by the learned single judge on 24th of April 2024. There was a direction that only if he has a valid license, broadcast will continue. May I request Lordships at page 17? It is not that this order has come about suddenly.
Page
17, what if I'm not in
15. Yes.
15, 16, 17, 18, 19, I'm sorry, 19.
Yes, yes.
Page 19. Lord, may I request at para 3, Lord, learned counsel, that is my learned friend, Lord, who was appearing for this Bitcoin. So and so undertakes to enter appearance for respond number 3, Bitcoin Infra Project Private Limited. He would submit, Lord, Lordships may kindly note, that he is having a valid license being granted by Union of India to run the show. Therefore, till the matter is heard and disposed of, whoever is possessing the valid license from the hands of the competent authority shall run the show. This was the order. And the matter was again, my lords, posted on the next day, that is more than 2 months later, that is on 26th of June. We were pursuing the writ petition as it is. It is at that point of time, Lord, the central government actually came about and informed the court that the question of either Bitcoin or Power Smart India Limited running the broadcast does not arise because the original proponent of the license, that is Messrs. Bitcoin's license has come to an end. Lords, my learned friends, Lords, made submissions before your Lordships that this document was for the first time given to the learned single judge. It was
Notices to Bitcoin.
yes. Bitcoin, that is the original person who held a license. Now, Lord, may I request Lordships to kindly see the additional document application which they have filed today. Lordships may kindly peruse that. But it is not that this document was produced for the first time. But may I humbly request Lordships to kindly peruse the additional evidence, additional document applications they have filed today. That application they have filed today, Lord. If Lordships are to kindly peruse that. Sorry, I'm sorry. There, Lordships will notice that they have participated in the proceedings, replied to this very show cause notice. But may I request Lordships to kindly see page 8, document number 1, which they have filed today, is the final show cause notice dated 9/2/2024. Document number 2.
How many show cause notice?
I'm sorry.
One. Only one.
Only one final show cause notice.
Final.
Yes. They had issued earlier also. This is the last show cause notice. But now, may I request, Lord, document number 2, which is at page number 16. This is written by Midcon Infra Project Private Limited on 26/2/2023. Lord, acknowledge, may I request that, Lord, document number 2 at page number 16. Lord. My Lords have it. My Lords have it. Kindly permit me to read the first paragraph itself. Lord. Reply to final show cause notice dated 9/2/2024. Messrs. Midcon Infrastructure Private Limited was granted permission via Ministry's letter number dated 13/10/2011 to uplink and downlink a news and current affairs TV channel, namely Power TV, in accordance with the then policy guidelines for uplink and downlinking of the satellite TV channels in India. The permission was valid till 12/10/2021, and the company has applied for renewal of permission on wide EE application dated on 3/12/2022. Therefore, my Lords, it is not that for the first time it was given before the learned single judge. He has participated, he acknowledges that my permission ended on 12/10/2021. Thereafter, I have filed an application. All that the learned single judge does not see is he takes notes of these facts and asks my learned friend, who was at that time appearing for the petitioners, respondent, specifically a question was put, are you aware of this final show cause notice? And the answer was yes. The answer was, not only we are aware of this final show cause notice, we are participating in the process.
Before learned single.
Yes, before the learned single judge. But today, certain thing, it may not be appropriate to make suggestions that for the first time a final show cause notice was given, they were sprung by surprise. Nothing of that sort happened. The next question which was asked was, do you have permission or license as on this day? The answer was obviously no. Therefore, my Lord, consequentially, an order was passed to stop broadcast, giving them an opportunity to show cause what they would say, as by 9th of, that is Tuesday. And the matter has been directed not to broadcast, they were directed not to broadcast up to 8th. That is how the entire proceedings actually transpired before the learned single judge. But as regards renewal of permission is concerned, Yes, that's the But as regards this granting of permissions to television channels or renewal modes, but according to me, it's a very serious issue. And the government of India has laid down policy guidelines, which includes a security clearance from the Ministry of Home Affairs. But these very guidelines have been interpreted by the Honorable Supreme Court to say, even at the time of renewal of permission, the clearance of the Ministry of Home Affairs is required, security clearance is required, they cannot be taken as granted. But may I request Lordships, only one paragraph I want to read. This was a case where a television channel was denied renewal. But their Lordships were dealing with this very guidelines. But in this judgment, which is not reported in 2023 SCC Online SC 366, one of the questions was whether denial of renewal of permission is necessary. At para 21, may I request para 22? Not para 22, if Lordships are to get. The following issues arise in the course of determining the validity of the order issued by MIB, that is Ministry of Information and Broadcasting, refusing to renew the uplinking and downlinking permission granted to MBL to operate the television channel Media One. One of the questions which their Lordships posed was whether security clearance is one of the conditions required to be fulfilled for renewal of permission under the uplinking and downlinking guidelines. Now, my lord, kindly see the answer to this question, which my lords will find at para 184, my lords. Page numbers. Page numbers. Para 184, conclusions and directions. What page? There's no page numbers. I'm sorry, there's no page number somehow. Missed out on.
Page number 80.
Yes, para, I'm getting para 184 if Lordships have to see. In view of the discussions above, the appeals are allowed and the order dated so and so and the judgment of the High Court dated so and so are set aside. We summarize our findings below. 1. Security clearance is one of the conditions required to be fulfilled for renewal of permission under the uplinking and downlinking guidelines. Therefore, my lords, this is not something which they can come before your Lordships and say that today we don't have a permission, we have filed a renewal application. Till that is considered, we will be allowed to broadcast. In fact, their contention, my lords, in the appeal, Lordships may permit me to read this, runs directly contrary to the ratio laid down by the Honorable Supreme Court. May I request my Lordships to kindly see internal page 15 of the appeal memo. This is their contention. Ultimately, this is what they say. Internal page 15 of the appeal memo. May I request? Internal page 15, ground number 28
of this judgment.
Internal page 15 of this appeal. The appeal or which they have filed. 951.
Yes.
Yes, internal page 15. Lordships kindly see. This is their contention. It commences from the word sentence. The respondent 1 accords permission to such entity as per the procedure established under Rule 4 of the policy. Such permission granted under Rule 4 shall be valid for a period of 10 years. Internal page.
Yes.
Internal page 15.
Yes.
At it commences from the sentence as per Rule 5. This is the as per Rule 5 read with Rule 4.4 of the said policy. The respondent number 1 is liable to communicate such refusal of renewal to the entity in the circumstances where there is no order of refusal to renew the said permission, it is deemed to be in effect until such order of refusal is communicated by respondent. Their entire appeal is based on this sentence, where they say until refusal is communicated to us, we are bound to continue to broadcast because deemed permission is required. But Honorable Supreme Court says, no, it is not automatic. MHA clearance is required. It is a very serious issue. It's almost as if granting a fresh permission.
But it will depend upon the language of the.
Yes, language of the rule itself. And there is no rule suggesting deemed approval. In fact, Honorable Supreme Court, therefore.
So this is only an argument, not the something flowing from this provision.
Not from the provision. It's an argument which has been advanced. But their case is this. And in what background? But background is not, of course, I'm grateful. My learned friend, Mr. Dhyan referred to page 165. But I also was also looking at that. In fact, the allegation is there is some threat of national security as against one of the directors of the appellant notes at page 169, if lordships are to see the number of cases which are pending against him. Whether I shall call it an illustrious background or 18 cases, criminal cases, which includes cheating, breach of trust, forgery, knowing, using forged records, extortion, house trespass. I don't know. And contempt cases.
Against whom?
Against the director of the second 18 plus there are 16 contempt cases which have been filed, non-violation of most of the injunction orders, which Mr. Dhyan Chinappa was gracious enough to point out. In fact, I had not noticed it. His background is record. These are all things which they are bound to, they will look into it. The government of India must look into it, find out whether these things should go on. And a suitable decision will be taken. Until then, in the absence of a license, it's a very serious issue. Broadcast cannot be permitted.
I am for the second respondent in the connected writ appeal. My learned friends have virtually left nothing for me to submit.
Who are you?
I am the senior most IPS officer of the state.
That is hardly relevant before this court.
No, I should just.
We are asking your name.
Since my lord posed a question to me as to
Asking your
who are
status.
you?
Not that status. That is thoroughly relevant.
Certainly.
The petitioner is senior most police officer.
No, because
Don't
it's-
mention such things before this court.
Yes.
We are court of law and we are not distinguishing anything by such designation.
No, I thought since my lord posed a question
Please
to me as
kindly
to
tell
who are
me.
you, that is why, my lord, I submitted to your lordship.
You must understand what is the query.
Yes.
It is a court of.
I am the
not a layman making a query.
I am the second
So
respondent.
he may be a senior most police officer, senior most politician, senior whatever he may be.
I am the second.
Please tell what is your good name first.
I am the second respondent in the appeal.
What is your good name?
My name, my lord,
What else?
C.V. Nagesh.
If you are going to make a relevant submission, then make, otherwise the whole submission.
Settle. That is what I submitted to your lordship, my lords. My learned friends have left virtually nothing for me to submit, other than inviting my lord's kind attention to 2 or 3. May I just request your lordship to kindly turn to ink page 38 minutes,
Page
38,
38, yes. Which?
in 951.
950. Yes,
But may I request your lordship to kindly turn to page 38 now?
yes.
Your lordship would notice how many cases came to be filed against the third appellant, who is the managing director of the first appellant.
Yes.
Well, a number of suits for injunction against him. Injunction came to be granted. But with impunity,
Name of the petition.
I'm sorry, my lord. Page 38. I given the chart.
Yes.
I would obtain or I would get the benefit of an order of injunction against the third appellant and his organization, that is the Power TV, not to telecast per se defamatory and malicious contents against me. But I get the benefit of an order of injunction in more than one case. I would even make an application, despite the fact that an order of injunction came to be granted against him, he would continue to telecast per se defamatory and malicious allegations.
That is your case in the petition. We have read it. Despite injunction, they went on to tell it.
What I would do, I would make a motion for action against him under the provisions of the Contempt of Courts Act. That your lordship would get. May I just request your lordship to kindly turn to page 40.
Yes.
Not only me, several persons who would go to the court, get the benefit of an order of injunction, and in utter disregard to the order of injunction which came to be granted by the jurisdictional civil court, he continues to telecast malicious or per se defamatory matter against one and all. That your lordship would get at in page 40, the contempt of court cases against him. My lord, may I just request your lordship to kindly go back to in page 38 now for a second. Well, 15 criminal cases are registered against him. Not one, 15 criminal cases are registered against him at different police stations in the city of Bangalore on the basis of the complaint filed by several of the agreed persons of the telecast which you would make, touching their character and conduct, which is palpably false. Therefore, I would go and make an application before the Government of India and the Information and Broadcasting Ministry. I would make an application. In my application, I would state the license that has been granted to him would expire in the month of October 2021. Initially, it was granted for a period of 10 years. It would expire in October 2021. The renewal application seeking for the renewal of the license that has been granted to him under Section 4 of the Act, well, it came to be made for the first time 1 year and 3 months later to the expiry period. Therefore, he should be stopped with his activities which has been carrying on. That was my request before the Ministry of Information and Broadcasting and also the Government of India. I would address several communications, one communication after the other. Then finally, my lord, they would open their eyes and my lord, they start initiating some action or the other, and finally it concludes in issuing a final show cause notice in the month of February 2024. My lord, this would be in addition to the submissions which came to be made by my learned friends. That is why, my lord, I submitted to your lordships. Nothing much has been left for me to say. My lord, even for the purpose of renewal, have a look at Section 4 of the Act, my lord. Well, this is what, not only for the purpose of obtaining the registration, but also for the renewal of the license that has been granted. Well, he has got to make the application. Well, in terms of the guidelines that has been issued.
When this litigation started.
Yes.
And your litigation started, this entire litigation.
Well, in terms of.
You are the host. Kindly listen. When this litigation started with your petition, you are the host. Now you are the guest. Yes.
I'm sorry. Well, it's under section 3 of the Act, my lord, no person shall operate a television network unless he is registered as a cable operator under this Act. Well, he comes as within the definition of section 2A small Roman 2, he being the broadcaster. Well, even for the purpose of renewal also, under Section 4, he has got to make an application. Any person who is desirous of operating or is operating a cable television network may apply for registration or renewal of registration as a cable operator to the registering authority. My lord, the guidelines would mandate, may I just request your lordship to kindly have a cursory look at the guidelines? Which your lordship would get.
149.
Well, at page.
149.
Yes, 149. Grateful. It commences from 149. It consists of 4 chapters. Well, at chapter 1 is preliminary. We will leave it. Part 2 is the teleporter/teleporter hub. Then, my lord, chapter 3 or part 3 is uplinking of television channel. Chapter 4 is downlinking of a satellite TV channel. Well, these are the condition precedents for him either to seek for the registration or for renewal. Merely because they have permitted him to uplink or downlink, well, they can't contend that it is a case of renewal of the license which stood expired during the month of October 2021 itself. He has been carrying on with his activities without holding a valid certificate of registration or a license that is issued under Section 4 of the Act for the last 3 years, more than 3 years. Well, here, at page 156, my learned friend invited my lord's kind attention to Rule 9.
Yes.
A company/LLP which is given permission at para 7 may apply for renewal of permission at least 3 months prior to the end of the month in which the initial permission is due to expire online on the broadcast Seva portal on payment of processing fee specified under Appendix 1. His application itself is in December 2022, that is 1 year and 3 months later to the expiry of the license that had been granted to him earlier for a period of 10 years. Even this license that is going to be renewed, again, my lord, would extend for a period of 10 years, as my lord would find in 9 subclause 2. The permission for renewal for a period of 10 years and shall be subject to conditions similar to that required for a permission under para 6, 7, 8, and to the further condition that the channel is not found guilty of violation of terms and conditions of permission, including the violation of program code or advertisement code on 5 or more occasions during the period of permission. In the event of the license being renewed, but that would give him the benefit of carrying on with his activities for a further period of 10 years, unless and until, my lord, it is cancelled for one reason or the other, or for the violation of the provisions of the act or the rules made thereunder or the guidelines. It gets extended for a period of 10 years. Unless and until he demonstrates before your lordship that despite the fact, it is an admitted fact, that he had sought for the issuance of a license as early as during the year 2011. If need be, my lord, I can take your lordship to his pleadings in the memorandum of writ appeal itself. That stood expired, my lord, during October 2011. 21. I'm sorry, 21. And it is only during December 2022, 1 year and 3 months later to the expiry of the license that was granted to him, but he would seek for the renewal of the license. Well, can he contend before your lordship that the permission that was granted to him under these chapters 1, 2, 3, and 4, which is a condition precedent, either for the issuance of a license or for the renewal of a license, is nothing but a renewal of the license which stood expired in November 2011. But if my lords are persuaded to accept my submission, that as on this day, right from 2011, November 2011, he does not hold or possess a valid license for the purpose of the operations, his operations.
Since 2011.
2011. I'm sorry, 21. I'm sorry, I stand myself corrected, my lord. Well, could he be permitted, whatever may be the action the concerned authority is likely to take in or in relation to the complaints that are given, in respect of which, my lord, he was served with show cause notices and all that, for which he has also replied, that is a different aspect. Let them take action, whatever action they propose to take. But in the absence of a license, he holding a license, The question is, could he be permitted to continue with his operations would be my respectful submissions.
That is all. Everybody. Yes. What is your submission?
Lord, my submission, Lord, is that the Honorable Court, at best, my Lord, could have only directed the authority concerned to answer this question as to whether there is a violation by us or not. And the reason why I'm saying this, my Lord, is the first paragraph of the show cause notice
Learned judge could not have stopped the.
could not have stopped the operations. At best, could have been a direction. Why I'm saying this is, it is not as if, my Lord, the ministry was not cognizant of the fact, which my learned friends, my Lord, are so elaborately submitting today, that the license and the renewal application was pending before the ministry from 2021. And that's the first paragraph of the show cause notice. But that is not the ground for which we are called upon to respond. Because 2021, we made an application. Till 2024, there is no problem. Even after 2024, the ministry is not saying, because we have not renewed your license, you must stop. Show cause why we should not stop you forcibly. The grounds are the various things that they have alleged against me, that you changed this, all of those things. And those are the grounds raised. Lord, as a matter of fact, the judgment which they pointed out to your lordships, just now, a copy of which, my Lord, they refused to give us. If my Lord kindly sees that judgment, Supreme Court actually came down heavily, my Lord, saying non-renewal of a license violates Article 19(1)(a). Please see that judgment, my Lord, which they pointed out to your lordships, my Lord. I hope they gave your lordships a copy, my Lord. My learned friend, Mr. Navagi, pointed out to your lordships one judgment. I don't have the benefit of an iPad. I still am on paper.
Beka?
Yeah, I got it.
185. 184.
Yeah, 184.
That judgment supports us, my lord.
Beg your pardon, my Lord?
The one which is relied.
Which they handed over to your lordships and not to us. That one, 184.
But they are
Now it's not.
broadcasting limit.
Yes, Lord. Conclusion and directions, para 184. I'll read that next, Lord. Please see. 184 in 184.3. Lord, there is 184, 1, 2, ABC, my Lord, goes on in the facts of the case. Please see point 3. The challenge to the order of MIB, my Lord has that. Challenge to the order of MIB is allowed on substantive grounds. The non-renewal of permission to operate a media channel is a restriction on the freedom of the press, which can only be reasonably restricted on the grounds stipulated in Article 19(2) of the Constitution. Reasons for denying a security clearance, that is, its anti-establishment stance, and the alleged link of the shareholders to JEH and not legitimate purposes for the restriction of the right to freedom of speech protected under Article 19(1) of the Constitution. In any event, there was no material to demonstrate any link of the shareholders as was alleged. In this case, not as a matter of fact, I looked at the facts very quickly. There was an application for renewal pending. When it was pending, a show cause notice was issued pointing out various violations, including these. And then an order was passed. That was challenged before the court. But when the renewal was going on, Lord, the media channel continued to operate. And not just that, ultimately the Supreme Court, my Lord, says at para 188, if your lordships may kindly see para 188, please see the direction. And Lord, civil appeals are allowed. MIB shall now proceed to issue renewal permission in terms of this judgment within 4 weeks. And all other authorities shall cooperate in issuing necessary approvals. Interim order of this court shall continue to operate until the renewal permissions are granted. And Lord, a media house, Lord, if I may respectfully say so, can't be stopped at the whim of a particular party. It can certainly be stopped at the decision, Lord, consciously taken by the Ministry of Information and Broadcasting. It cannot be a party saying, oh, there are 15 criminal cases against him or 20 criminal cases, and therefore stop the media house from promoting or putting up any news online because it is not convenient to them. If that is the case, Lord, then there would be no right of freedom of speech under Article 19(1)(a). It would mean that a person can tomorrow complain and get an order to stop.
Now, in the show cause notice, what is alleged, the violation of guidelines or abusive use also?
Yes. Please see, my Lord.
Violation of guidelines.
Not
While
abuse.
not abusive, violation of guidelines that without obtaining the permission of the government, they have let it out. That's
No, please see 19. I think the show cause notice speak for itself. My lord. Please see the show cause notice at page 8. Page 8 of the application for additional documents filed by us today. Please see the show cause notice. My lord, the first paragraph,
Misuse the permission.
I beg your pardon, my lord?
Yes, read what you want to.
May I just read the first paragraph itself?
Under examination. Yes.
paragraph 3, my lord. That paragraph 3, 4, 5, 6, all of them must speak about unauthorized permission being granted.
For everything, there's an answer also.
This is a show cause notice. I have to respond to it and
Give
have
an
an
answer
answer.
to every paragraph.
I didn't know, my lord, show cause notices are orders by themselves.
That is the only thing, violation.
Violation of the permission. Yes,
Now,
nothing
the-
to do with our right.
So the first paragraph, my lord, of this says permission has come to an end. It is under examination. Now, on the basis of that, the next paragraph says it is imperative that the permission holder company has to abide by the terms and conditions of the applicable uplinking and downlinking guidelines at all times in letter and spirit. And thereafter, various reasons are given. Your lordships will see on the next page: content generation, content transfer, content uplink. These are the three issues, para 4. At para 4 on page 9, hence the company who owns the permission of a news TV channel must also have control over its core operation, content generation, content transfer, content uplink. And they've asked us for all the documents with respect to those three issues. Now, I asked myself, if there was no permission, there is no question of going into the next part of content generation, content transfer, content uplink. Therefore, the stand of the ministry has always been that so long as an application for permission is pending, there is no question of saying you cannot operate. Otherwise, my lord, please see, and I'll show you, lordship, what is most startling in this case, which is, of course, argued now completely contrary to it. Page 46, the last page of the same document, of the same application. Each of these entities have their permissions, my lord, and licenses under process today for extension, including, my lord, Bloomberg, if my lord sees 0.6 Bloomberg, 0.8 Lamhas, 0.11 BBC. BBC Global News India Private Limited, which has the BBC channel in India, has, my lord, its permission for renewal pending today. And this is, my lord, straight from the Ministry of Information and Broadcasting. Each of them, my lord, are broadcasting today. And if I may say so with great respect, you can't choose one party and then say, I'll issue a show cause notice, but even before I pass the order, I'll stop it from operating, which is exactly what has been done. This entire list are channels which are in India being broadcast as on today, even as of now. Hindi news channels, English news channels, all of them have their renewal applications pending before the ministry.
Lord, I'm sorry, on that, my lord, I have received the copy only this morning. I will have to verify. I don't concede the allegation that all of those are illegally.
Let my learned friend check. I have no difficulty. I understand. In the same way that we had the difficulty of, as lawyers, of responding when a show cause notice was handed over in court. I completely understand my learned friend's difficulty in responding to a document which I've handed over today. And therefore, they must be given time. But then, I would respectfully say, my lord, merely because my permission is pending, could it have been done by the learned single judge in this particular fashion of stopping us overnight and saying, don't uplink, don't downlink, don't broadcast anything as of now? That I would respectfully submit, my lord, is an order which is really egregious in nature and affects, my lord, my fundamental right to publish. If I'm wrong in publishing something which is not palatable to the two petitioners who have come to court, there are mechanisms by which they can stop certain content. But to stop all content and say, I mean, this is like the best punishment, my lord, that they can mete out to us. You have taken steps against me. Now I have ensured that you are stopped. That, in my respectful submission, my lord, can't be done. Those are my respectful submissions.
My lord, I'll just take a few minutes, my lord. I think the manner in which, my lord, they have placed their case is, my lord, completely contrary to the methodology, my lord, which the government ought to have applied. Lord, the first submission they made was that from 2021, we had no license. There's no show cause notice issued. No, 2021, your lordships may recall, is COVID. After COVID was the time when we filed the application. And the Honorable Supreme Court orders, my lord, says all periods fixed in any law will get extended. Now, from 2021 till the issuance of this current show cause notice, no notice is issued to me saying that you don't have a license, you are operating, stop your activity. No notice is issued. On the other hand, they proceed on the basis that I can continue. And whenever I made an application for change of name of the channel, change of teleport, change of satellite linking, every single application is considered. If, my lord, the stand of the central government today is that I should not have operated at all, then I ask myself a question, my lord. Would any sane officer grant these permissions? If so, why have they granted the permission? This is their conduct, my lord, which has to be borne in mind, so far as the manner in which they are now trying to do. My lord, so far as these complainants are concerned, my lord, they have nothing to do with the enforcement of this law. It is between the government and us. And government has not taken action. My learned friends, my lord, pointed out that show cause notice is issued. For want of time, my lord, just to save your lordship's valuable time, I did not read, my lord, but I will just show your lordships where those replies are. Every single point, my lord, in the additional affidavit that I filed, starting from page 16, I've extracted the allegation, I've given the answer. Each allegation, my lord, which they made, saying you don't have a studio, somebody else has got a studio, I've explained it. I produced the documents. I produced proof to show how much money was paid to whom. Every single allegation, they had some doubt about the address, where is it operating from? I give them proof. Now, after all this is over, they don't take a decision. And it's still pending. Now, my lord, at this juncture, my lord, my respectful submission is the learned single judge ought not to have granted such an order. The best order that could have got is for the government to consider and take whatever appropriate action there. Because till today, there's no show cause notice that should stop operations. Now, my lord, in a situation like this, my lord, when the prayer is to consider, could they have granted such relief is a question, my lord, that falls for kind concern. I agree, my lord, an interim order is discretionary, not to be interfered with. But if the interim order is going far beyond the final order, giving the final relief itself, nothing more remains in the writ petition, my lord. If this order is confirmed permanently without an order from the government that I should stop, this will come into effect. My submission is that that's not the intention of this legislation at all. That's not how it should be done. My grievance, my lord, was not that I didn't know about the show cause notice. My lord, on the date of hearing, which is uncontroverted, they just pulled this out and placed it before the court. So not filed with any memo, with any affidavit, with not part of the petition. At the hearing, my lord, if they place a document like this, and the learned judge looks into that, and then says all this, where was the occasion for me to file this reply? That's why I sought your lordship's kind permission and filed this. If this had been placed before the learned judge, matter would have been different. But that was not placed for this reason, my lord. This is the manner in which the hearing went on before the Honorable Court. Therefore, my lord, my submission is that it's not a case, my lord, for granting of such reliefs. The decision which my learned friend, my lord, referred to Mr. Chinappa has already referred to that, my lord. In fact, in that case, one of the contentions was you need security clearance for giving you uplink port. In this case, they have given me uplink port in March of 2024. Your lordships have seen it. They've given me that permission to say you use this. Then who is arguing that the security clearance is important, it should be given? That means, did they give it to me without security clearance? Obviously, they've taken security clearance and given to me. Obviously, my application for renewal is pending with them. They say that in the notice itself, they say it's under examination. Now, the object of an interim order, my lord, is to preserve the status quo as it prevails, my lord, on the date parties come to court, till the honorable court takes a final decision in the matter. If I am in possession, don't disturb my possession. If I am doing some activity, don't disturb. But if their case was that this is how it was done, the earlier interim order, my lord, says I have a license. My argument is, and my learned friend has pointed out, not how many channels are being run without a license. My lord, this is a serious inroad, my lord, into press freedom and freedom of expression. After all, a news channel, my lord, does not only publish some ABCD items, it publishes everything. And Honorable Supreme Court in the latest decision, my lord, have very specifically said that this freedom should be preserved. The hallmark of a good democracy, my lord, is you cannot stifle speech, free speech. And if free speech, my lord, if according to some people, my lord, I have committed act of defamation, I'll face the trial. But that cannot be a ground. My lord, if we extend that a little bit, my lord, people in public life, my lord, whether maybe in the private sector, or in public sector, or in government service, they have a lot of people who have grievances against them. Many of them file complaints. Many of them file criminal cases. How many cases government grants permission to prosecute a civil servant? How many times they give permission to prosecute a politician who held a position as a minister or MLA or whatever it is? They are all, that means what should happen to all of them? They should all be locked up in the jail. Today, my lord, the situation is that a person who is elected when he is inside the jail comes and takes oath in parliament as a member of parliament. That's the law of this land. Merely because there are criminal cases against me, somebody has chosen to file defamation case against me, I'll defend it. My lord, there are people, my lord, who live in glass houses. They can't throw stones at others. They are the people who ought to be, my lord, disciplined now. Not me, because I am pointing out so many ills of society, which they don't like. Therefore, they've used this backdoor method of silencing me completely. You know, I have employees. I have contractual obligations. 300 people are working for me. If I don't air my channel, I don't get advertisement revenue. 100 crore advertisement revenue is what I'm generating. All of this is completely stopped. That can't be them, Lord. Interim relief is my submission. Great.
But you telecasted one program for 11 hours?
Yes, my lord. The program runs 24 hours also. If needed, my lord, it will run.
This is not touching the controversy.
Yes,
We are not going anywhere except law.
Please.
Lord, the fundamental right can be protected, my lord, in a judicial proceeding like this, where there is existence of a prima facie legal right. But, my lord, here are two appellants, my lord, who have conceded.
That was not their case.
Please wait, please. They have conceded that their license has expired on 12th of October 2021. But they're carrying on only on the ground that I have renewed some other teleporter license. So is there a prima facie case for them to carry out? Answer is no. So therefore, my lord, in a rule of law jurisdiction, my lord, in a writ jurisdiction, lordship can see whether they have a right to carry on the business or not.
My lord, my learned friend was not the writ petitioner. He was a respondent in the writ petition. Why is he so vociferous? If, my lord, he had power and the government wanted to take action against me, all the power in the world was available, but they didn't choose.
True.
Now they're trying to
piggyback
on own, two persons
obligation on me
who have no interest in my company and whose only interest is to scuttle me. They're writing piggyback. Exercise your power. I will challenge it in appropriate proceedings. They don't want to do that. They want to come encourage somebody and ask him to go to court and use his shoulder to shoot. Why did you not take action from 2021 against me and all the other channels? That's a question, my lord, which the government has to answer, and they can't come and support this order. They have no locus standi to support the order.
State government is not coming.
Government has nothing.
So now no time. Tomorrow at One court will dictate.
Yes.
Tomorrow, day after, day after.
Hey, dictation.
No, no.
Dictation.
I'm in Dharwad tomorrow.
For dictation, if you want, you remain present day after tomorrow. I have no.
No, my lord, your lordship, they proceed to orders, my lord.
Tomorrow.
It's only a dictation. Great. We'll be there to give any assistance if needed. That's all. Any page number, things like that. That's
Yes.
all.
Lordship's leave minutes. With my lordship's leave minutes.
My lords, my lords, I'd like to mention serial number 34, my lords.
Let's may I make one submission, my lord?
With my lordship's leave minutes, number 51 minute that relates to that elephant, my lord was pleased to include. That's listed today minutes. 12 to 16, I will not be in India, therefore any other day, either this side of 12 or after 16.
Name is not mentioned.
Please, sir.
Your name is
No,
not.
name is mentioned. From 12th to 16th, I will not be there.
19th.
Please, sir.
My lord, serial number 34, my lords.
One submission. In the event we are not here, hope your lordship should kindly condone our absence and proceed to our.
No, you need not be here. If you want to be here, you are welcome, but not anywhere else.
In the
Any
event,
other,
our absence is.
any
kindly
other court,
condoned.
yes, yes.
That's.
Serial number 34, my lords. Serial number 34. Serial number 34.
Yes, what do you want?
For the last several months, my working is totally stopped. They could not produce the forest notification, my lord. And I think time is up, my lords, maybe taken up on 16th of this month, my lords.
Serial number 55, my lord.
81, my lord.
Serial number 55, my lord. It's regarding that child custody with grandparents and parents. The parents and they were supposed to come today and they have come also, but it was not taken up maybe,
Some other day,
maybe end July.
end July, 29 July.
29.
Serial number 59. The date may be assigned next week.
Tomorrow,
I'm ready to.
tomorrow.
My lord, serial number 46, my lord. My lord, it's related to the wildlife on the Dandeli reservation forest, my lord. So there's a railway track going past it and killing a lot of wildlife over there, my lord. Kindly have a date fixed. my
Tomorrow.
lord. Yes, my lord.
Tomorrow,
Serial number 58.
not tomorrow, not
So serial number. Yep, tomorrow.
tomorrow.
Yep, tomorrow.
No, tomorrow.
Tomorrow.
Tomorrow we can,
Yep,
tomorrow.
There are several matters in my absence.
No, your matter will be there among several matters.
Tomorrow I will take.
Malad, serial number 77, Malad.
Yes.
Along with the connected matter, Malad, the lordship has directed to be posted on 24/7 to them.
Court master is veto power.
The earlier granted stay may be extended, Malad, till the earlier.
Tomorrow.
No, this is the 24th, the connected matter has given state appeal, Malad. This is the state appeal.
What do you want?
And I wanted to pray this honorable court, Malad, kindly have it this along with the 30A W up, writ appeal number 30A of 2024, which is posted on 24/7/2024, as per directions of this honorable court yesterday. So this today, serial number 77 tagged with that, and earlier granted stay in this case extended.
Serial number 79. Violation of court WP orders. Kindly issue notice to respondent.
Sir, serial number 53. Sir, serial number 53, sir. Serial number 53.